Pronouncement of judgment, item 55.
We have allowed the rectification. We say that due to the earlier judgment, the university and the authorities are barred by principles of waiver, estoppel, and acquiescence. Now it cannot be denuded.
For pronouncement of judgment, item 56.
Appeal dismissed.
For pronouncement of judgment, item 61.
Here will dispose of with some directions.
May I please, your lordship, I beg to mention item number 7 of today's list.
Yeah.
Lordship, here I'm seeking an adjournment on behalf of the finance department, lordship. The arguing counsel, due to some medical emergency, we cannot argue the matter today, lordship. I've informed the other side, lordship, the petitioner.
Adjourn.
Bless you.
May I please, your lordship, with the consent of the other side, I beg to mention item number 10 and 11 of today's list, my lord. And it will be list next week, my lord.
Adjourn.
Highly obliged.
May I please, lordship. Lordship, with the consent of the parties, I beg to mention item number 8, lordship.
Item number 8.
Item number 8, lordship.
Yeah.
In this matter, we have been led by senior counsel, Mr. S. Poplo, but today he's in Another therefore I'm praying for an adjournment.
Adjourn. Adjourn.
May it please your lordships, my lord, I beg to mention item 23 to 31 and 37, my lord.
Yeah.
In this case, Mr. Ken Choudhury will lead in this case, my lord. So next Thursday, my lord, 13 of this month.
18, 17 to 52.
17 to 15.
52.
52.
Oh,
Yes, my lord. We are also on item number
same.
same as 22, my lord. 22 and 45, 40. 22 also, my lord, my senior counsel.
Thursday, my lord, 13.
These repetition, writ appeals and petitions. Not Thursday. Then it will go after summer vacation.
Oh,
After summer vacation. At the request of so and so, just after the summer vacation.
my lord, can you fix a date, my lord? Otherwise,
Summer vacation, you get the date from the registry.
highly obliged.
May I please your May I please your lordship, with the consent of the other side, I would like to beg item number 14. Senior advocate from DN Panda from Orissa is supposed to argue the matter. I pray for adjournment for 6 weeks, your lordship.
Item number 10.
14.
1 4.
1 4.
14. 14.
Adjourn. Summer vacation.
May I please, your lordships? Your lordships, with respect to item number 15, your lordship, with
Yeah.
the consent of the state respondents, your lordship, the matter may be adjourned, your lordship.
Adjourn.
Much obliged, your lordship.
May I please your lordship?
Lordship, with the consent of the other side, I beg to mention item number 53 and 54. The matter may be adjourned for today.
Adjourn.
Obliged, Your Lordship.
Orders, item 1.
It's too much. People are asking के matters list नहीं हो रहे हैं. List हो रहे हैं उसके बाद में क्या हालत होगी?
My lord.
List हो रहे हैं, the whole of the list is almost adjourned. Yes.
My lord, here I have filed a progressive proof. As per schedule, it is going on, my lord. And this, an entire 2 lane will be completed in our affidavit. That is by March 2025. Because no, this schedule, it is going on, my lord. Whatever schedule was given 10 kilometers up to our lordship will give. Entire things were ready. Ordered. Progress
They have
and-
filed an affidavit
Yes, it's today I have to file affidavit, my lord.
today.
No, Saturday itself.
On the
That is
laptop,
why this last occasion it was adjourned, my lord, as the affidavit was not waiting.
First June, yeah.
Lordship got it. Page 164, my lord, we have stated. Last. Lordship got it.
No, some progress has been made. Previously, it was 19.4. Now it is 26.34 million. Lordship will monitor for some time and
Yes,
let them,
Certainly, certainly.
Yes,
yes, million.
definitely, my lord. That's why our
what is the total stretch?
detailed state, my lord,
26.23.
26.23,
And how much has been done?
16.6.
So around 10 kilometers
Yeah.
remain.
This will be completed by 25 March. We are getting target.
You are
Mm.
taking time up to March.
No. I'm not taking time on that. Completion of work will be, construction is going on, my lord. As per schedule, it is going on. Even entire road, we are.
Basically, this is the whole.
It was situated to reach.
15th already.
এইটো কমপ্লিট কৰিছে না এটা পাৰ্ট কৰিলে না আগত হলে ভাল কথা আমিতো এক্সিডেন্ট
Pursuant to the direction given by this court
লাগি আছে
on 3/6/2024. If pursuant to on 1st of June, cut them, pursuant to judge, on 1st of June 2024, 2024, the respondent number
here Miller Dam or 2 Miller and it's a
Respondent number 2 is filed an affidavit indicating the progress in construction of the road from
Jatinga to Haringa.
from Jatinga to Harangajo section.
Full laning work on Jatinga.
Indicating the progress in the four laning work of Jatinga Harangaon section in bracket package AS 21
Till 31/5/2000.
till 31/5/2024. It is indicated that around 16.5 it is indicated that out of the total length of the road, that is 26.23 kilometers, around 16.16 kilometers, two lane has already been completed, and the whole project would be completed by March 2025. Full stop. Taking
All
into
project means,
consideration,
let me clarify, not subject to this permission. Here, two lane is going on Miller. Four lane means two lane will be completed, that is by 31st, two lane. Because whole means it may interpreted with four lane, because it is two, out of four lane, two lane progress is going on. First, we are making two lane. That is, we have especially mentioned Miller by two lane.
work would be completed by March 2020.
I love.
Full stop. Taking into consideration the above facts narrated in the additional affidavit, we deem it appropriate to this matter on 4th of October 2024. In the meantime, the respondent NHA shall file a progress report
Right.
indicating the work completed up to 30th of September
Right.
2024 on 3rd of October 2024.
We'll file.
Just on 4th of October 2020.
Oblige.
Deeply.
Item 425.
Lordship. Lordship, usually Lordship, PILs are filed to resolve Lordship problem affecting the legal rights of the community, Lordship, or the public at large. Lordship, PILs are filed to safeguard the interest of the common people and not individual interest, Lordship. In my present case, Lordship, I have no individual interest, Lordship. To that effect, Lordship, I have also filed an affidavit in reply to an affidavit in opposition filed by them, Lordship, by the registrar who had filed objecting my Lordship filing of these cases, Lordship. That Lordship, I think Lordship have gone through, Lordship, and the Honorable Court have issued notice, Lordship, way back in on 8/5/2022, Lordship, 23, I'm sorry, 8/5/2023. After that, Lordship, so many respondents are there, Lordship. None of them have cared to file an affidavit before this Honorable Court because they cannot, Lordship. Whatever I have stated here, Lordship, in the PILs, Lordship, all are made up from the documents which I have received from through RTI, from the AAU authorities only, Lordship. Almost all of them I have acquired these replies and Lordship, everything related with my PILs.
Yes.
Lordship. And regarding Lordship, the Lordship on the last occasion asked me, Lordship, about the High Court rules, Lordship.
Yes.
There is a notification, Lordship, and it is of 1988, Lordship. The notification is of 1988. They have not reviewed it, Lordship. So many PILs have been filed, Lordship. So many PILs have been filed since 1988, Lordship. They should have reviewed it, Lordship, and have brought to the notice of the lawyers, Lordship, show this notification, Lordship, that such and such have happened. Such and such cases have issued this kind of orders, Lordship. And I have gone through, Lordship,
Which is that notification?
Lordship, page, Lordship. This, Lordship, our High Court rules, Lordship.
Yeah.
Lordship, may I read you?
Page.
Page, Lordship, 478.
478. This is the guidelines.
This for letter petition. Yes. Letters petitions.
No petition involving individual public personal matter shall be entertained as a PIL matter except as indicated herein after, Lordship.
Yes.
And thereafter, Lordship, what Lordship had pointed out, that is their Lordship. Lordship, if we come to Lordship,
In which category of these 9 categories,
Lordship,
in which category your case is falling?
Lordship 8. Petitions pertaining to environment pollution, disturbance of ecological and so, Lordship. And last line, and other matters of public importance.
What are the matters of public importance?
Lordship, the anomalies, the irregularities, that is,
So read whole this.
Lordship,
It's
Lordship.
cases falling under the categories will not be entertained as public interest litigation, and these may be returned to the petitioner or filed PILs as the case may be landlord tenant matters, service matters or those pertaining to pension and gratuity. Service matter and those pertaining complaint against central, state government department, local bodies except those relating to item number 1 to 10. Admission to the medical and other petitions for early hearing the case pending in the subordinate courts. And concerning maintenance of so and so. So there is a specific bar, complaint against the central, state, department and local bodies.
Lordship,
There is a
Lordship.
specific bar,
Lordship,
and thereafter, the rules have already been formulated. After this notification,
Lordship,
this Guwahati High Court Public Interest Litigation Rules 2011,
Lordship.
they are in force now. So here, definition of public interest, this is given. In which of the instructions for filing PIL in the public interest litigation, Rule 10. Now, whether these Rule 10, all the conditions mentioned in the Rule 10 has been complied with by you or not? This was the specific question we have raised.
Lordship. Lordship, regarding service matter, Lordship. Lordship, recently, Lordship, an order has been passed by the Honorable Court, Lordship, in Lordship. I'm coming, Lordship. Lordship, may I pass this order, Lordship? Lordship may come to paragraph 4, Lordship.
You have referred this order earlier.
I have never referred, Lordship. On the last,
Some other advocate
Lordship,
other
I was
PIL.
not there, Lordship, maybe.
in other PIL
Lordship.
filed by the petitioner themselves, this order was placed before.
Lordship, I'm sorry, Lordship, I didn't know. Lordship. Lordship, regarding,
It's a
Lordship,
debatable issue.
Lordship, it is a debatable issue, Lordship. Pertaining to what, Lordship, I bring forth before this honorable court, Lordship.
So, this, order dated, this judgment dated, Dr. Grievance House still holds the field.
Lordship,
Still holds the field.
Lordship, still hold the fields, but these have been turned as
This will be
debatable.
debated, before the appropriate forum. and
Lordship,
appropriate
even in,
forum is only
even in
appropriate forum.
Dujidan case, Lordship, what has been stated is that, Lordship, these matters should not be taken up, PIL should not be taken up by the administrative tribunal, Lordship. That was very specific in Dujidan case, Lordship.
Later on, this, after following this judgment in the repetitions also, there are
Lordship.
several judgments.
Lordship,
Says-
I have gone through some, Lordship.
Yes,
Lordship, my basic allegations, Lordship, in the 4 PIs, Lordship, I have compiled it in
that,
short, Lordship.
we have also done some homework.
Lordship,
In PIL number 1,
Lordship,
this first PIL number 1 of the 2023.
Lordship,
Establishment of the departments without approval from the chancellor.
Lordship,
This is what your first allegation.
Lordship,
Thereafter, in this, your PIL itself, you have come with the case that now the approval has been granted by the chancellor,
Lordship,
as per your information.
Lordship.
Okay,
Subsequent stages, Lordship, in between that, Lordship,
this is what.
Lordship,
Misuse of fund for foreign trips of university teacher and officers.
Lordship,
So you mean to say that we'll look into all this misuse of fund in the foreign trips and all. Now, embezzlement of tribal subplan, for
Lordship,
that you have already filed an FIR,
Lordship,
that is there. Then improper banking transaction, transfer of university funds to Axis Bank.
Lordship,
So we'll look into that,
Lordship.
is there any criteria, is there any rules that the funds of the university can only be transferred to the nationalized bank and not to the private bank? Is there any provision which prohibits them?
It doesn't prohibit, but Lordship,
Then,
Lordship, if that is inquired upon, Lordship, it will be found that there was embezzlement of
now another
Lordship,
appointment made during 2/8/2013 to 17/3/2016 shall be quashed and set aside.
Lordship.
This is what your,
Lordship, exactly, I do not
Yes, sir.
stick to it.
yes, you
Lordship.
have in earlier para, you have specifically said, yeah, though I am not
Lordship.
against those, but your prayer is there,
Lordship, Lordship,
okay? Now, sending escorts guys to foreign tours with the
Lordship.
students.
Lordship, that,
You are objecting to this also.
Lordship, that was prohibited by Lordship,
This is-
the Lordship,
Now
that
come to the second PIL.
Nahab had objected to it,
All
Lordship.
these PILs are filed on the very same day.
Lordship,
And for in first this related to this, then placing the procurement of seed embezzlement, the seeds embezzlement of money, this is what your allegation is. For that, you have already lodged an FIR, that is pending investigation.
Lordship,
Then leasing out land to IHT Noida,
Lordship,
complaint filed with the governor, that is pending, and
Lordship.
FIR is also there, that is
Lordship.
pending.
Lordship,
Procurement of plant, something, facility, that you have challenged.
Lordship.
Unauthorized purchase of luxury vehicles,
Lordship,
sale of land to AAU to another university, for in relation to that, you have already filed an FIR.
Lordship,
Okay. Now PIL number 3. Promotion of 93 associate officers
Lordship,
to the post of professors. Promotion of 2 assistant officers to the associate officers. Appointment of more than 150 assistant professors and equivalent post here under challenge. Granting permission to Mr. Kabita Bhuyan, associate professor, joint duties. Illegal award of degree to Munni Bora, MS Munni Bora.
Lordship,
You have not made her party. PhD degree, how they have awarded her PhD degree, you have not made her party.
Lordship,
Okay. And all these other matters are purely service matters related to appointment and promotion.
Lordship,
Right? Now, this PIL number 5/22.
Lordship,
illegal and unauthorized constitution of service statutory officers, officers of Assam up to 65 years. That they have illegally allowed the continuance of some of the persons up to 65 years.
That's it.
Illegal appointment of non-existent post, chief executive officer post of 11 and above. These are the
Lordship,
points
Lordship,
by and large in the PIL.
Lordship, Lordship.
So these last two PIL purely in relation to appointment and promotions,
Lordship.
and that is clearly barred. In relation to the other allegations, you have already filed an FIR
Lordship.
and everything. And first of all, you have to explain that in the very same day, you have filed 4 FIR
Lordship.
containing different allegations. What is this? You filed such type of, while putting some of the issues in one of the and some of the issues in another PIL. This is purely misuse of this.
Lordship, what if Lordship?
And nothing else.
On the last occasion,
Yes.
on the last
Abuse
occasion,
of the forum and nothing else.
on the last occasion, I have pointed out to a Lordship that lot many allegations were brought to me, Lordship.
Yeah.
I have gone through them. I have found what supporting documents you have from my client, Lordship.
Okay.
So those documents which were available to me and
That is altogether other thing.
Lordship,
That from where you got these documents and all, we are not.
only
actually
those cases I have
functioning
filed,
there.
Lordship.
But what is this?
Lordship, otherwise,
Why
Lordship,
4 PILs on the same day?
Lordship, otherwise
containing
it would,
different allegations.
it would have been voluminous, Lordship. In one PIL, it would have been voluminous, Lordship. All the allegations I didn't want to bring into.
So still it
in
is
one.
there, these PILs you have filed, they are not voluminous.
They are voluminous, still they are voluminous, Lordship, because I have placed all the documents, Lordship. And Lordship, on the last occasion, Lordship said whether I have approached the chancellor again, Lordship. This is it, Lordship. I have again approached Lordship recently, Lordship, 7th May 2024. I have approached the chancellor again, Lordship.
Mr. Bhagavati, do you agree that there is only one prayer in all these 4 and the other PIL? One prayer only.
Lordship.
Cancel the appointment of the VC. That's the only.
No, Lordship. I have
No,
never
no,
made
no.
this, I have never stated that,
No,
Lordship.
no, you have not stated it,
No, Lordship.
but in disguise, that is the only reason.
That is not the reason, Lordship, because Lordship, most of the allegations were from other 2 VCs also, Lordship. Allegations against other 2 VCs who are no longer holding the post, Lordship. This is the 3rd one, Lordship, and it has been, the process has been continuing. That is the crux of the matter, Lordship. The process that was initiated earlier, Lordship, that is still continuing. I want to stop it, Lordship. And Lordship, I asked my client, Lordship, why were these issues not raised earlier?
Yeah.
He said that about 4 or 5 cases were filed, Lordship. I could collect only 2, Lordship. I didn't have sufficient time, Lordship. And Lordship, some inquiry was also made, Lordship. And in one case, Lordship's brother judge was also there, Lordship. Against Buzar Borwa, there was some inquiry, Lordship. And Lordship, I cannot get that order, Lordship. Yes, I have it, Lordship. Lordship, I have one, Lordship. There was an inquiry against him also.
It was before us. In fact, they have filed this in along with their preliminary objection.
Lordship,
This order is already there.
Lordship.
Yeah.
There was another case, Lordship, what Lordship one pointed out to me, Lordship, whether I am against the VC, Lordship. Earlier VC, there was against some inquiry was there, Lordship, and your Lordship's brother judge had passed some order, Lordship, that is and matter was dismissed, Lordship. It was there, Lordship. So I also asked the same question, Lordship, whether if these are continuing for so many years, Lordship.
Yeah.
Why were they not placed before this honorable court, Lordship? That point I also raised, Lordship. And he said that 4 or 5 cases were there. One I have given, Lordship. There is another, Lordship. I cannot bring a second copy, Lordship, because of paucity of time, Lordship. I was extremely busy in the last 6 days, Lordship.
What has happened to this order? Any appeal?
No one filed a Lordship. Who will file, Lordship? No one came forward, Lordship.
You were there.
No, Lordship. I came across this
You are so
recently,
vigilant.
Lordship.
You are the.
I could not even make a second copy,
You are
Lordship.
looking into day-to-day affairs of the university. Should have filed it. Why you not
Lordship,
filed earlier?
Lordship, it came as an outcome of another PI, Lordship.
Okay.
There was a second PI, Lordship, which I cannot
Wherein-
make before this
wherein
honorable
the
court. I
notice
do not
was
have it,
issued to the vice chancellor and that notice was set aside in
Lordship.
this.
Lordship.
Yes.
And Lordship, there was an observation that they could, what Lordship had pointed out, they should have made a fresh inquiry, Lordship. They didn't do it, Lordship, because Lordship, officials of Lordship AAU, how can they challenge the vice chancellor, Lordship? That is another issue, Lordship. The vice chancellor is too powerful, Lordship. And these kind of issues are nowhere in other universities, Lordship, in Assam, Lordship.
Are you sure?
Lordship, not that objective here, Lordship.
Are you
But-
sure? Are you sure?
Lordship, I have not seen anything about
If I
Guwahati
that
University.
no such illegality is there in
That
the,
I cannot, Lordship. That I cannot.
that you cannot,
That I cannot.
then this is nothing but targeted litigation and nothing else, and proxy litigation, in fact. And nothing else.
Lordship, see their affidavit, Lordship. That is a proxy affidavit, Lordship. Their affidavit, Lordship. They have, register have filed it, Lordship. All allegations I have brought against this Kamal Malla Bujar Borwa, that has only been answered, Lordship. In their affidavit, they objected, thereby they objected.
Still, they have not filed a reply to the petition, they have simply objected to your credentials. They've highlighted your conduct.
Lordship, I am a,
And they have also demonstrated some of the attempts. which were
Lordship, I am a
made earlier
public activist,
before
Lordship.
this court.
Lordship, I am a public activist, Lordship. I have several
That's
issues,
why
Lordship.
last occasion also we have asked you, you are a public activist, you are very much concerned about the well-being of the public. How many PILs raising
Lordship, these are
concern
some of
about
the
the
issues, Lordship.
other matters of the state you have filed?
Lordship, these are some of the issues I have raised in the public domain, Lordship.
There are this 6 PIL petitions,
5, 4.
two already
Lordship,
there by
there-
another concept.
Those are Lordship,
In relation to the, we are only talking about this petition,
Lordship,
6 PIL petition.
Lordship.
4 are these PIL petitions. One is challenging the appointment of the VC. That is a co-warrantor
Right.
petition. And another is challenging the appointment and something else.
Lordship.
This is what. And with regular intervals, all these petitions were filed in November 2022, these 4 petitions, and other petitions were filed subsequently.
That two should also have come together, Lordship. Very
Together that we have already heard and on the maintainability. That
Lordship,
order is already reserved, and today also it is for the maintainability.
Lordship.
So the pointed question again, we are repeating that in the rules of this 2011,
Lordship.
there are certain instructions, whether you have followed those instructions by filing this PIL or not.
Lordship.
This was the pointed question last time also and today also. You first satisfy us that yes, you have complied with all these instructions, then we'll proceed further.
Lordship. As per the requirement that has been stated in the notification or Lordship PIL criteria, Lordship, to fulfill the criteria, Lordship. Simply because these are public issues, Lordship, they do not cover these guidelines, Lordship, like bonded labor, neglected children. These guidelines does not come here, Lordship. These are issues which are all
Sir,
are
rules of 2011,
Lordship.
That is there at page number 488 in this very book.
Lordship. Lordship, I'm
These
sorry,
are
Lordship,
statutory rules.
I didn't have much time, Lordship.
Okay, we'll see together today.
Lordship,
We'll see together.
Lordship.
Since you are aware of all the amendments made in the petition, we'll see together.
Yes. Lordship, in the part to page 489, Lordship, letter
Yeah.
petition, Lordship. Lordship, There are some guidelines have been in serial number 8, Lordship.
Yeah.
Lordship, letter petitions raising or alluding to matters of public interest shall be entertained as a letter petition, and unless directed by the public interest litigation committee, letter petitions under the following categories shall not be entertained as public interest litigation. Lordship, landlord-tenant dispute, Lordship, this is not my case. Lordship, service matters and those pertaining to pension and gratuity. Pension and gratuity is also not there. Service matters to some extent, Lordship, I want inquiry, Lordship. Not to take away the service, or I want to place someone, not like poor warrantor.
With the prayer to quash those appointments.
Lordship,
With the prayer,
Lordship.
you want an inquiry with the prayer to quash these appointments or set aside these appointments.
No, Lordship, first inquiry should be there, Lordship. If found
So
irregular, Lordship.
that is not the only prayer you have. You have specifically said these appointments should be set aside. Yes, next.
Lordship, personal disputes between individuals. I do not have personal dispute, Lordship. I am nowhere related in with Assam Agriculture University.
Number 3, you have left it.
Number 3, Lordship, personal dispute.
Complaint against central government, and this 88 notification you are referring to, or which?
Lordship, page 489, Lordship,
489, yeah. 489, that rules.
rules, Lordship. Serial number 8, Lordship.
So letter petitions.
Lordship,
It
that
is
is-
not a letter petition.
Lordship, this is not letter petition.
Not a letter petition.
Lordship,
So why you are referring to this?
complaint, number 3, Lordship, as Lordship pointed out, complaints against central, state government departments and local bodies except those relating to
Again,
item number
you,
1 to 10.
First, you complete with this rule 2011, whether you have complied with or not. Instructions, filing of public interest litigation, rule 10.
Lordship, a writ petition intended to a public interest litigation shall contain an instruction immediately below the number of the writ petition in the title, namely in the matter of a public interest litigation, especially averment in para 1 of the writ petition to the effect that the writ petitioner has no personal interest. That I have stated, I think.
Yes.
Interest in the litigation, and that the petition is not guided by self-gain or for gain of any other person, institution, body, and that there is no motive other than public interest in filing the writ petition. A specific averment in para 2 of the writ petition as to the source of the knowledge of the facts alleged in the writ petition and the further inquiries investigation made to determine the veracity of the same. That I have stated, Lordship, Lordship. A specific averment in para 2 of the writ petition specifying the class of persons for whose benefit the petition have been filed and as to how such persons are incapable of assessing the code themselves. That I have filed in the reply, Lordship. That question was raised earlier
The
also, Lordship.
requirement is of para number 3 of the writ petition. Requirement is para number 3 of the writ
Lordship, that is there, Lordship.
is there. You have not done.
While preparing, Lordship, it may have passed my mind, Lordship. That is there, Lordship.
Okay.
A specific averment in para 4 of the writ petition of the body of the person's bodies institutions like to be affected by the order sought in the writ petition and which who shall be implemented as respondents, and a further averment that to the knowledge of the petitioner, no other person, body, institutions are likely to be affected by the order sought in the writ petition. A specific averment in para 5 of the writ petition of the background of the petitioner with qualification as far as it may be material to show the competence of the petitioner to espouse the cause. If the petitioner is an organization, the name and address of its office bearers and the nature of the activity shall be stated. And averment shall also be made by the petitioner has the means to pay the cost, if any, imposed by the court and on the undertaking of the court in that respect. Okay, that I have to go through the petition, what I have
In
written,
the petition itself, you have to mention all these things.
Lordship,
Para number 5.
Lordship. That I do not know, Lordship, I have to go through, I do not
No,
remember.
no,
also.
since you should have asked them that if you are paying my fees, From if the court impose the cost, how will you pay that cost? What are the means? What are the resources? By the way, what is the qualification of the petitioner?
I think he is a graduate, Lordship.
You have mentioned it in the para number 5.
Lordship, that I may not have, Lordship. Lordship, para 2, I have stated that the petitioner is a permanent resident of house number so and so. His address has been given, Lordship. The petitioner is a social and RTI activities and the state president of Hindu Yuva Satra Parishad Assam. That much I have given, Lordship. The HYC Hindu Yuva Satra Parishad Assam is a nationalist organization since birth of this organization in Assam in 1992. The Parishad has been relentlessly advocating Hinduism as nationalism and has been fighting against the secessionists and anti-national forces and has been advocating for a corruption-free society.
But here in para writ petition, background of the petitioner with qualifications so far as may be material to show the competence of the petitioner to espouse the cause.
Lordship. That I have missed out, Lordship.
You have not submitted.
That I have missed out.
Then come to other paras.
In para 6 of the number Z, in para 6 of the writ petition, details of the representations made to the authorities concerned for remedial actions and replies, if any, received thereto shall be set out precisely. This I have given not exactly in para, but in subsequent stages I have placed them, Lordship. If the petitioner has previously filed public interest litigation or preferred letter petitions, the details, these, to my knowledge, when I filed it, Lordship, there was no PIL filed by him, Lordship. So, Lordship has pointed out that 2 other petitions have been filed, Lordship. That at that point of time, I didn't know. These are subsequent. Pleadings in brief divided into paragraph setting forth the cause which has given rise to the filing of the petition shall be pleaded, followed by grounds in support of the prayer, followed by prayer clause in the last paragraph giving precise prayer which the petitioner wants to be granted by the court. Prayers I have given, Lordship, in several ways, Lordship. Provided that if the petitioner is unable to provide information for any of the matters above, there shall be a specific agreement as to the reason why said information is not being provided. 1 or 2 RTI have not been replied, Lordship. That also I have stated, Lordship. And the rest I have, as much as I can, Lordship, I have provided, Lordship. Adjournment number Z, adjournments made in the petition shall be supported by an affidavit verifying the following affirmation by the petitioner disclosing the statement which are true to his knowledge or true to his knowledge derived from information, disclosing the information or true to his knowledge derived from record. Every public interest litigation shall be accompanied by an affidavit as per pro forma A annexed to these rules.
Yes. Coupled with this notification dated 88 of the 88.
Lordship. No petitions involving individual public personal matter shall be entertained as a PIL matter except as indicated hereinafter.
Yes.
Lordship, letters of the petitions falling under the following categories alone will originally be entertained as public interest litigation. These I do not, as I already stated, Lordship, these I do not cover because these are related to the affairs of the Assam Agriculture University. Lordship, these matters, these 10 Lordship, more or less Lordship, it doesn't cover Lordship. The issues I have raised Lordship.
So this is what you
Lordship.
say on the maintainability. Any, something?
Lordship, on the last occasion, Lordship had asked me whether I have provided, again approach the with these disputes, Lordship, with these allegations, Lordship. Recently, Lordship, I had gone to him again, Lordship. The Honorable Lordship Chancellor said that the allegations which were placed before him, he was not even aware. Not aware. He didn't know that we had filed some complaints in his office, Lordship. It was not placed before him. He said, give me a copy. So we had filed, we had compiled it, Lordship, a big one, Lordship. Everything, Lordship, we have again placed before him.
You have already placed.
Lordship.
Then what happened?
Lordship, I am awaiting for the 7th May, Lordship, recently.
So despite that, you have approached the chancellor. Still, you are insisting that we should pass any order in this petition, in these petitions?
Lordship, since Lordship on earlier occasion, Lordship, I have placed before
When you have moved this application, the representation?
this one. Recent one is Lordship 7th May 2024.
Okay.
Mr. Bhagavati, would your client like to withdraw these PILs and pursue the matter before the Honorable Governor and in accordance with law, and so far as the FIRs are concerned?
Lordship, I have to take the instruction from him.
Take instructions, will, to
Today, Lordship, today.
10 minutes,
10 minutes.
or if you want 12.
Lordship,
12 minutes.
sometime maybe you can, I may not be able to contact him, Lordship. That is,
Public
two,
spirited
Lordship,
person, he
at
will be
two-
available every time, every
at
minute.
2, Lordship.
He's a public spirited person.
Oh, Lordship is rising at 1. I didn't know, Lordship. Lordship, I can take the instruction.
After some time.
Item 6.
Obviously. Move it. Masih dulu. Not cool kan? Not cool. Move something. It's long time and very cool. Yeah.
You are ready to argue the writ appeal itself today?
Since my lord, in the IA also, I filed my lord. IA filed my lord. In the IA, I have prayed before this honorable court, since one representation that is here in the appeal and close to at page 122, that has been pending, Annex W. my lord. And pendency of this writ appeal, if otherwise they consider this representation, then since he is going to be retired in the month of October 2024, my lord.
We are ready to hear this writ appeal itself today. Argue it out.
Yes, otherwise notice was served. I'm ready, my lord. Otherwise, if lordship otherwise say, or interim also.
What interim order?
No, this IA was filed, my lord.
IA, leave aside the IA.
Yes,
Argue the writ appeal itself.
yes.
Yes. Argue it out.
My lord, now. Then, if lordship will hear, my lord, as a whole, my lord, then I have to prepare the book list, my lord.
Prepare that.
This, the judgment, my lord, whatever judgment I have, my lord, that I have to prepare, my lord, to supply your lordships. For hearing, my lord.
Okay, will consider those.
Lordship. Lordship will find the impugned judgment of this honorable court, my lord. Firstly, my lord, before going to this impugned judgment, I must appreciate lordship's this earlier honorable court's order of the single bench, my lord.
Yes.
Lordship will find at page 91, lordship.
Yes, 91.
Yes. 91, my lord, 5376, 2021, my lord. Here, the appellant is at serial number 3, Dhirendra Patwari. The honorable court
Petitioner number 3.
yes,
Dhirendra
Patwari.
Patwar.
Lords.
Yes.
Here, my lord, the relevant portion of the order starts from page 93, my lord. 6/10/2021.
Yeah, that is there.
Here, my lord, it has been stated that the case of the petition is that they are presently working in various posts in the Assam Secretariat and that their service conditions are governed by the Assam Secretariat Service Rules 1963, which is now repealed and replaced by Assam Secretariat Service Rules 2019. Under Rule 5(5) of Assam Secretariat Service Rule 2019 regarding recruitment to the post of superintendent by promotion, it has been prescribed as follows. Superintendent recruitment to the post of superintendent shall be made by promotion from the select list prepared for this purpose under Rule 7 from amongst the senior administrative assistant in the secretariat who rendered not less than 5 years of continuous service as senior administrative assistant on or before the first day of the year in which the selection is made and have passed the Group B training or equivalent as prescribed by government from time to time. Provided that a candidate must have possessed graduate degree in any stream as academic qualification from any recognized university. That's the new rules, my lord. Earlier only higher secondary pass was there. Now, by virtue of the new rules 2019, the graduate degree has been inserted, my lord. Now the whole problem arises thereafter. It is projected that the petitioners have all completed 5 years of service in the rank of senior administrative assistant prior to 1/1/19 before the Assam Secretariat Service Rules 2019 was notified on 13/6/2019. It is projected that under the Eastwhile 1963 rules, the petitioners were otherwise eligible for promotion with higher secondary pass qualification And therefore, the new set of rules are to their disadvantage. Therefore, the petitioners are seeking relaxation of educational criteria for their promotion to the next higher post of superintendent. The Learned Counsel for the petitioner has submitted by an office order dated 24/6/19 issued by the deputy
Come to parent number 7.
lordship. 6,
Without
7.
going into the merits of the case.
Yes, as projected by the petitioner that the Assam Secretary Service Rules 2019 contains provisions for relaxation of rules without examining the merit of the claim and without adjudication of the matter. The court is of the considered opinion that ends of justice would be met if the repetition is disposed of at this motion stage by directing the Chief Secretary to the Government of Assam, response number 1, who is the competent authority under Rule 2A2 of the Assam Secretary Service Rule 2019 to dispose of the representation of the petitioner dated 9/6/20, Annexure M, Annexure N, as well as representation 11/12/20, Annexure O, submitted by the Assam Secretary Services Association within a period of 2 weeks from the date of receipt of the download copy of the order together with a copy of the repetition. With all enclosures, the response number 1 shall be at liberty to verify the order from the website of the censor. The response number 1 shall furnish a copy of the order to the petitioner who would accept it for the himself and on behalf of the petitioner.
So
In
the court has directed to decide your representation.
Yes, then
They have now decided your representation.
they decided representation thereby without considering the Rule 16.
Rule 16 and relaxation, they have refused to
They
give you the
they
relaxation.
refused to, my lord. That lordship will find the order, my lord. That is page 118, lordship.
Yes, 30th of October 2020.
Yes, yes. My lord, there are 3 writ petitions, my lord. And the 3 writ petitions together, it has been taken into consideration. And here, it has been said, basically in 119 and 120. Here, 120, my lord, whereas the Secretariat as Administration Department has replaced the earlier service rule by the Assam Secretariat Service Rules 2019, where the recruitment to the post of superintendent shall be made by promotion from the select list prepared for this purpose under Rule 7 from amongst the senior administrative assistant in the Secretariat who have rendered not less than 5 years of continuous service as senior administrator on or before first day of so-and-so, in which selection is made and have passed the Group B training or equivalent as prescribed by government from the time, provided that a candidate must have possessed graduate degree in any stream as academic qualification from any recognized university. Although the provision of Rule 16 stipulates that the government has the power to relax the provisions of the said rule, it is an exception rather than rule. If such a relaxation was to be given in such each and every case, the very purpose of enacting the new rules would be shall be defeated. Accordingly, the provisions of Rule 16 are to be used cautiously and not all the time. And taking the aforesaid circumstances into account and on careful examination of all aspects, it has been decided that as the petitioners do not possess the required qualifications for promotion to the cadre of superintendent, the representations submitted by the petitioner have been duly considered and rejected due to lack of merit. This is issued in compliance with the Honorable Court's order, so and so. Now, my lord, they are only giving the weightage to the graduation degree, not the higher degree. And had it been so, my lord, of course, for new recruitee, the Rule 16 may not come. But for promotion, my lord, person who are working for more than 30 years in service and they are going to be retired, at least that rule, since this rule has been enacted for that purpose, my lord, to consider those persons who are going to be retired, who have been caused hardship, my lord, by enacting that rule. That particular the rule has been specifically said that has to be considered, but that was not considered.
That's right, but
Then, lordship, next page 122, on the day of this rejection, again in the second of, my lord, this petitioner again submitted another representation.
Okay.
On the same day, on 30/10/2021. And this is, of course, pending without any disposal, my lord. Now, against that, my lord, we have come before this honorable court. In one case, I have enclosed in the writ petition, my lord, annexure 10, my lord, 124 page, my lord.
Yes.
In similar circumstances, my lord, this honorable court, single bench, my lord. Of course, it is in the case of relaxation of the rule for their overage. My lord, lordship will find, my lord. So and so considering the grievances expressed by the petitioner and the order that is proposed to be passed, the case is taken up for disposal of the petitioner are aspirant of the post of the veterinary field assistant, another so and so, so and so, so. They have completed certificate course training, so and so, so and so, science and animal husbandry, still in 1996, 97. Since then, they have been seeking appointment against the said post. In the meanwhile, government of
In relation to this appointment. not in
no,
relation
this
to
is
provision.
regarding this is regarding overage, madam.
Oh, that is the difference.
No, only I would like to say that regarding this relaxation only, that part honorable court considered. Taking into,
Relaxation for appointment in the upper age,
yes,
that is altogether
Yes.
different situation, relaxation in qualification.
yes. Now, yes, that qualification, my lord, since only I'm my lord, before this honorable court for relaxation of the qualification as per the rules. My lord, lordship will find at case this since then, my lord, this some of the petitioners, my lord, some of the persons, my lord, who are junior to me, my lord, they have been already promoted by virtue of notification. Page 128 starts from 128, my lord.
Without any requisite qualification,
No, here, my
they
lord,
were qualified now.
yes, they were in 2020. They were the qualified as graduate teacher, graduate person, my lord. Now, my lord, who are not the graduate persons, only higher secondary, their cases have been considered. Lordship will find Lordship will find at case at page 78, Lordship. Since the rule came into operation with effect from 13th of June 2019, Lordship. And page 78, 24th of June 2019, this serial number 2, he has been promoted, my lord, as who was the higher secondary, my lord. He has been made party. And serial number 4, he is higher secondary, my lord. Serial number 5, he is higher secondary. And serial number 11, he is higher secondary, my lord. And serial number 14, he is higher secondary. Then lordship will find serial number 23, he is a higher secondary. And serial number 24, he is a higher secondary. And serial number 34, he is a higher secondary candidate. Now lordship will find another page 80, lordship.
No, but they were promoted before the 2019 rules came into force or after that?
After.
Your consideration was prior to the notification of the gazette notification.
Now, secondly, I would like to rely page 80, lordship, annexure L. page
Yes.
80, Lordship.
Yes,
Similarly, my lord, this is done after about 8 months, 31st of December 2019, Lordship. There's serial number 3, Minal Chandra Das, he is the higher secondary, my lord. And serial number 2, Sambhunath Thakuria, he is a higher secondary passed. And they passed the B group training. They were eligible after the new rules come into operation. New rule come into operation in 13th of June.
they have passed this group B training prior to coming into force of rules of 2019.
No, this
Yes.
B group training, this Lordship will find in 30th December, page 80, Lordship. This serial number 2, he passed the B group training on 16/7/19 after operation of the new rules,
When did the new rules come into effect?
13/6/2019. And the first promotion was made on 24th June. I understood that, yes, if otherwise the whole process was completed and thereafter they have been appointed or promoted. If that is the position, in the case of 31st of December 2019, whereas the candidate were not qualified, they did not pass the B group training, but they passed the B group training in the month of July, 16th of July, 2019. And the serial number 2 passed the B group training on 16/7/2019.
So how has the learned single judge dealt with this part of the,
The learned Singulja did not deal with this.
did you plead that?
Yes.
Pleading?
Yes,
Where
in
is
the
that?
pleadings.
Where is the pleading in the writ petition?
In the writ petition, Lordship will find. Lordship will find at para 6, Lordship, page 39, Lordship. This is in the writ petition, my lord. It was specifically stated, my lord, that the petition stated though the new rules of 2019 has come into operation with effect from 13/6/2019. Interestingly, the DPC was held on 24/6/21 and White Government of Assam notification so 24/6/19. Totally 40 numbers of senior administrative assistant who were in similar footing of petitioners were promoted to the post of superintendent in different establishments, and accordingly they joined in the promotion post on 25/6/19, including graduate degree holders. In contrary to the new rules 2019, the below named employees had the qualification of higher secondary examination passed, that is undergraduate. However, the authority concerned of Government of Assam have considered their promotion to the post of superintendent by serial number 2, 4, 5, 7, 11, 14, 23, 34 under the old rules 1963, namely Rajgar Singh, so and so, there is 8%. Next, my lord, as per the and 7, my lord. 6 and 7, my lord. The impugn notification, my lord, 24/6/19, and page this para 7 also, it has been said that the persons who passed the B group training on 16/7/2019 and 4/11/19, Lordship 7, my lord. Para 7, my lord. That again, White Government notification dated 30/12/2000.
What is the response of the state government in reply to this amendment?
My lord, nothing has been stated specifically, my lord. That Lordship will find. Number is located. Location 139. Lordship will find the affidavit of the government, my lord, 139.
139.
139. Now 6 and 7, my lord. Para 8, my lord, they have stated in para 8 and 9. That with regard to statement made in paragraph 6 of the writ petition, the answering deponent humbly begs to state that as aforesaid in paragraph 2 and 4, the DPC meeting was held on 4/6/19, which was prior to the date of effect of new rules 2019. Therefore, the promotion was governed by the Assam Secretariat Service Rule 1963, and as such, graduation degree for the post of superintendent was not mandatory, and the incumbents were promoted as per their gradation list. It is denied that the department selected the candidate in pick and choose policy. With regard to the statement made in paragraph 7 of the writ petition, the answering deponent humbly begs to state that the meeting held on 24th December 2019 was an extended session of the meeting held on 4th June 2019, as stated in paragraph 2, and the incumbents were promoted to the post of superintendent accordingly. It is a fact that promotion was governed by the old rules 1960, even though the gazette notification of the new rules 2019 was published on 13 June 2019, because it was suggested by the selection committee in the DPC held on 4th June 2019 that the department would process the proposal for relaxation of qualifying service for promotion to the post of deputy secretary, and after obtaining approval, the promotion of under secretary to the government deputy secretary and consequently promotion to the other cadres would be given. But in deputy for promoting to the post of deputy secretary, the rules have been relaxed. But in my case, they have not relaxed. They have admitted. And
So, Mr. Chetri, in case of others, the DPC had met before the new rules were notified. You are not in the same footing.
no, here, my lord, the DPC was held in one case, para 6, my lord, in one case, prior to the operation of the new rules, they hold the DPC. My lord. Thereafter, whatever the promotion has been made, that has been made on the basis of the prior DPC, my lord. Prior operation of the new rules, my lord. Now, in the 31st of December 2019, that promotion, my lord. That promotion, my lord, the person who have been promoted, my lord, they were not eligible prior to the new rules came into operation. They were not eligible. Only after the new rules came into operation, they were they passed the B group training.
Yes.
Then only they were eligible for
Yes.
promotion.
Yes.
And if that being the position, my lord, similarly, I have also passed. And below than me, some of the persons have been promoted, my lord, below than me. And that is why, my lord, I have come before lordship that if the new rules, instead of applying the new rules, if they promoted with the old rules by defining.
Relaxation, essentially you claim for relaxation.
That's true, my lord.
Well,
Now, since the new rules, I am not disputing anything else. There are so many decisions this way, that way, my lord. But I am only praying, my lord, since there is a pragmatic, this rule is there. So, this honorable, this High Court as well as this Apex Court also said that this at least pragmatic view should be taken, since the rule has been given to relax the educational qualification, or since the persons had he been the new recruitee, matter is different, my lord.
Yeah.
I would not have been, my lord, on this point. But since the persons are working in under the old rules for 30 years, my lord, abruptly new rules have come, my lord. Now that for that rule, I have been debarred, I have been stopped from promotion, my lord. Is that the case, my lord?
Yes.
Lordship, in this case, Lordship, there are three applicable rules, Lordship. One is Secretariat Subordinate Rules 1963, under which the petitioners are presently working, Lordship. Next was Assam Secretariat Secretariat Service Rules 1963. That has been repealed, Lordship, by the new rule of 2019. And the new rule is Secretariat Service Rule 2019. Lordship, total 17 petitioners are there, Lordship, out of which 5 and 10 has been already promoted, Lordship, and 3, 7, and 11, they retired already. Now, Lordship, may kindly see the last column.
These are the promoted.
Lordship, 5 and 10 has been promoted subsequently.
3, 7 and
5 and 10 Lordship promoted subsequently.
5 and 10
Yes, Lord.
also promoted.
Yes.
Achha, 5 and 10, yes, promoted then.
Then 3, 7, and 11, they retired, Lord. 11 retired in 2021, 7 retired in 2022, and 3 retired in December 2023.
Right.
Now, Lordship, may kindly come to the last column, Lordship,
Last column,
of that sheet, Lord.
yes,
Lordship, may kindly see these are the dates, Lordship, on which the petitioners qualified the Group B trading.
training, yeah,
Lordship, first one, 16/7/2019,
that is appellant.
appellant number 1. Lordship, new rule came into, new rule was notified on 13th of June 2019. So on that day, when the new rule came into effect, Lordship, none of the petitioners were eligible in terms of the earlier rule even, Lordship.
So-
So because of the new rule, Lordship, no right in respect of the appellants has been taken away, Lordship.
Yes.
So that is my first submission, Lord. Now coming to page 118, Lordship.
118,
Yes, Lordship, this is the impugn order, Lordship.
yeah,
And this order was issued in terms of the order passed earlier by the Honorable Court. I'm coming to page 119.
para,
Lordship, 1, 2, 3, third paragraph, Lordship, fourth paragraph. Whereas in 2019,
judgment of the Lalit Singhalji. or the
no,
next-
Lordship, it is 119. It is in the part of the writ petition, Lordship.
Impugn order.
The impugn order.
Yeah, yeah,
Third paragraph, Lordship.
Yeah.
Whereas, as per provision of Assam Secretariat Subordinate Service Rule 1963, recruitment to the post of superintendent shall be made by promotion from the select list prepared for this purpose under Rule 10 from among upper division assistant in the Secretariat who have rendered at least 5 years of service as upper division assistant and confirmed in that cadre. There was no minimum educational qualification fixed for the post. That was earlier. Whereas in 2019, the Assam Secretariat Service Rule 1963 has been replaced with the Assam Secretariat Service Rule 2019, which has been notified in the Assam Gazette on 13/6/2019 and came into force with effect from the official publication of the rule in the Assam Gazette. Therefore, the affected incumbents serving as senior administrative assistant without graduation degree submitted petition for relaxing their educational qualification and considered them for promotion to the cadre of superintendent. Whereas the petitioners have not been, petitions have not been disposed of, the agreed incumbents filed a writ petition being so and so. before the Honorable Guwahati High Court for Justice. The petitioners have filed a petition stating that few of their colleagues with similar qualifications have been promoted to the post of superintendent by the department after the amendment of the Assam Secretariat Service Rule. Whereas the department had held the selection committee meeting before the gazette notification of the amended service rule on 4/6/2019. That is prior to the enactment of the new service rule. Again, another extended session of the aforementioned selection committee meeting was held on 24/12/2019 and considered the candidate to the post of superintendent as per provisions of Assam Service Rule 1963. Whereas no candidate without required educational qualification, that is graduation, has been considered for promotion to the post of superintendent after amendment of the state rules. Whereas the Secretariat Administration Department has replaced the earlier service rule by the Assam Secretariat Service Rule 2019, where the recruitment to the post of superintendent shall be made by promotion from the select list prepared for this purpose under Rule 7 from amongst the senior administrative assistant in the Secretariat who have rendered not less than 5 years of continuous service as senior administrative assistant on or before the first day of the year in which the selection is made and have passed the Group B training or equivalent as prescribed by the government from time to time. Provided that a candidate must have possessed graduate degree in any stream as academic qualification from any recognized university. Although the provision of Rule 16 stipulates that the government has the power to relax the provisions of the said rule, it is an exception rather than the rule. If such relaxation was to be given in each and every case, the very purpose of enacting the new rules shall be defeated. Accordingly, the provisions of Rule 16 are to be used cautiously and not all the time. Taking aforesaid circumstances into account and on careful examination of all aspects, it has been decided that as the petitioners do not possess the required qualification for promotion to the cadre of superintendent, the representations submitted by the petitioners have been duly considered and rejected due to lack of merit. The representatives so-and-so submitted by the petitioners are hereby disposed of. So that is the ground taken in the impugn notification. Now, Lordship, coming to the judgment passed by the learned single judge, Lordship. Lordship, may please come to page 200. Para 8, Lordship. Page 200.
Yeah.
Par contra, Mr. So-and-so, learned counsel for the respondents argues the following. There is no discrimination between the petitioners and the private respondents. When the pre-amended rule was holding the field, the petitioners did not even require the qualification for promotion to the next higher grade in terms of the extent of Rule 1963. Whereas the case of the private respondents for promotion to the next higher post was initiated Rule 1963 when the said rule was holding the field and they had already acquired the required qualification at that point of time. Their recommendation for promotion was also made by the DPC prior to the enactment of Rule 2019, and therefore a conscious decision was taken to promote them. Therefore, the petitioners and private respondents cannot be said to be placed in a similar situation, and therefore non-consideration of their case under the power of relaxation provided in the under Rule 2019 cannot be said to be discriminatory in nature. 2, time and again it has been held by the Honorable Apex Court that power of relaxation cannot be exercised to relax the essential.
Yes.
So that is my submission, Lordship. Here, basically, I relied upon few judgments of the Supreme Court law. Now, coming to the determination part, Lordship, 202.
Yes, we have gone through that.
Lordship. So, Lordship, so far as the petitioners were concerned, Lordship, First, they were not eligible at the time when the new rule came into effect. Secondly, nobody without having a graduation degree has been promoted subsequent to the coming into effect of the new rules. And those persons who were given promotion without having the graduate qualification, their consideration was prior to the date of coming into effect of the new scheme, Lordship. Now, few judgment, Lordship, I would like.
So, Mr. Nayak, one query, how this serial number 5 and 10 were promoted among the petitioners?
Lordship, some DPs were pending against them, Lordship. That is why their names were not cleared earlier.
No, they are graduates otherwise.
They were not graduate, but initially they were under consideration, but their names were not recommended because some DPs or departmental proceeding was.
They were considered under the old rule.
Yes, not under the old rule. They were considered prior to the coming into effect of under the old rule. Lordship.
Under the old rule.
Yes, Lordship. So they were.
Okay. That's all.
Not a few judgments I would like to.
Judgments, learning single, we relied upon those judgments only.
Yes, Lordship.
Yes. The matter comes upon for consideration of the IA member. So and so, filed by the petitioner with the prayer to admit the writ appeal number 127/2024 and direct the respondent authorities to consider the representation filed by the applicant on 30th of October 2021 for promotion to the post of superintendent by relaxing the rule as per provision of Rule 16 of the amended Rules 2019, as the appellant is at the verge of retirement in the month of October 2024. Full stop. With the consent of the parties, the writ appeal number 127/2024 itself is heard finally. Hence, this IA is disposed of. And with the consent of the parties, the writ appeal is disposed of, close for all this.
Passover matter 225.
That's it. Lordship, petitioner have sought apology from this honorable court, Lordship. For Lordship filing the PILs, Lordship, he thought that this would be the best resort, Lordship, because he became remedialess, Lordship. So he had approached this honorable court, Lordship.
Now, what?
Lordship, he will file fresh memoranda before the chancellor, Lordship. That is it.
You are not pressing these petitions, our seeking liberty to approach the governor,
Lordship.
honorable the chancellor,
Lordship.
governor, the
Lordship.
chancellor of the university for
Lordship.
redressal of your grievance.
Lordship.
Okay. After the learned counsel, Mr. Mahanta, on instructions as.
Mr. Bhagavati. Mr. Bhagavati.
M.
Mr.
Bhagavati.
Bhagavati, sorry. Mr. Bhagavati, on instructions has submitted that the petitioner does not want to press these. Wants to withdraw these PIL petitions. However, seeking liberty to approach honorable the honorable the governor of state of Assam, come chancellor of the Assam Agriculture University, Jorhat, for redressal of his grievances essentially raised in these PIL petitions. Full stop. The counsel for the respondents has no objection if the petitioner is permitted to withdraw these PIL with liberty as prayed for, dismiss with liberty as prayed for.
That's all.
Common order and also.
Common order.
Right.
Supplementary list for orders, item 57 to 59.
Yeah, my lord, sec has already been taken by the Assistant Labor Commissioner from the Registry of General Report. He has already received the amount. Received there. Okay, and concept for the state has submitted that pursuant to the direction given by this court on 15/5/2024, the Assistant Labor Commissioner come authority has already moved an has already received the amount mentioned in the order dated 15/5/2024 from the registry of this court. It is from the registry of this court. Full stop. The registry is to verify the above fact and place a note before this court. But tomorrow. Tomorrow. This launch so and so. Monday would list. Monday would list. Just ask them to place a note whether he is received or not. Yes.
Item 60.
Lordship, in this case, there is a mistake on my part, Lordship.
Yeah.
The respondent filed two OA, Lordship.
Okay.
The wrong OA has been annexed. Let me bring by an affidavit the correct OA, Lordship. 1 week time may be granted.
You have mentioned the number of the OA wrongly or what?
No, the wrong OA had been annexed as an annexure, Lordship.
Okay. Okay, then the concept of the appellant, petitioner has submitted that due to inadvertence, the copy of the
OA 8 of 21 has been
copy
annexed.
of the OA number
8 of 21 has been annexed. It should have been 255 of 2020.
8/2021 is annexed, whereas the impugned order is passed in OA number 255.
255 of 2020.
2020, and council plays some time to cure the said defect, time paid for is granted. This after 2 weeks.
For hearing, item 9.
May I please, Your Worship, Worship, this petition has been filed assailing an order of the learned CAT, which Your Worship will find at page 110. Whereby, Worship, the penalty imposed upon the respondent was quashed. If I may give a brief background of the case, Lordship. In fact, here, Lordship, a demand draft of 2 lakhs, which was the public, which was the provident fund amount, was sent to the area organizer's office in Sikkim. and that has been encashed by somebody else. Then as such, Lordship, proceedings were initiated against the respondent.
Yes.
And the penalty was imposed upon the respondent, which your Lordship
Penalty order लगा ना?
penalty order.
The penalty order,
Penalty order, your Lordship will find at page 117 of the additional affidavit, Lordship.
Yeah. That is of 12/2/2016.
Yes, Lordship. And if I may take your Lordship to page 123. Paragraph 7. Now therefore, after careful consideration of the report of the inquiring authority, disagreement note, the disciplinary authority did not agree upon two penalties. Disagreement note. UPSC advice and the submissions made by Sri Viraj Bhattakur, SAO. The President has decided to accept the findings of the inquiry authority, this is agreement note, and the advice of the Commission, and concluded that the ends of justice would be met in this case if the penalty of reduction to a lower stage in the time scale of pay by 3 stages for a period of 5 years on the concerned officer, Sri Viraj Bhattakur, SAO, SSB, with further direction that the concerned officer will not earn increments of pay during the period of such reduction, and on the expiry of such period, the reduction will have the effect of postponing the future increments of his pay is imposed on Sri Viraj Bhattakur, SAO. Now,
Yes.
now if I may take your Lordship to the impugned order of the learned CAT.
Yeah, impugned order.
Of the learned CAT, which is at page 110 of the writ petition.
What is the order of penalty, Mr.?
At paragraph 7, Lordship, of the additional affidavit, Lordship. If I may read it, Lordship, once again. Reduction to a lower stage in the time scale of pay by 3 stages for a period of 5 years on the concerned officer, Sri Viraj Bhattakur, SAO, SSB, with further directions that the concerned officer will not earn increments of pay during the period of such reduction, and on the expiry of such period, the reduction will have the effect of postponing the future increments of his pay.
Was this appeal admitted? This writ petition?
Not admitted till date.
It is a state.
Admitted or not?
Just check. Leonard Fence says there's a stay, so I thought it was admitted.
Stay is there,
Stays there, Your Lordship.
but admission is there or not?
Normally, without admitting, there won't be a stay.
Stay order is there, but formal order of admission is not there. The order is 21st of November 2019.
Lordship.
Is for midnight, sir?
New order.
No, sorry.
Also final hearing.
1/11/2019. There is a stay order, but yes, this in 21/11/2019 is there. For the same reason, we hereby stay the operation of the impugned order. Formal admit it, then will pass in order.
Otherwise, it's been coming in the hearing list for few occasions, Your Lordship.
But,
It must have been.
For the, either Yadav will decide at admission stage, or if we want to decide it, then we'll have to admit it. Look here.
Otherwise, my prayer would be that if it is not admitted till now, let it be heard in the admission stage itself, Your Lordship. Because from 2019, the matter has been stayed, so the person is also suffering. Whatever happens, Your Lordship.
Admission column.
If the matter is not admitted till date, though the impugned order passed by the CAT has been stayed by this court on 21/11/2019. Stop. Since the pleadings are complete, we deem it appropriate to list this matter for hearing for final disposal at admission stage itself. List on when
Apart from 13th, I don't have any date, Your Lordship.
just after come this opening of the summer vacation.
Obliged.
It is there.
Government advocate.
Let's make item number 57 to 59 million. One council appearing for the so I submitted that pursuant to the direction given by this court on 15/5/2024. The Assistant Commissioner come authority have already received.
Assistant Labor Commissioner.
Assistant Labor Commissioner come authority has already received two account pay checks from the registry of the High Court amounting to rupees 3,61,869 and 1.25721 and rupees 12571 on 4/6/2024. In such circumstances. 64. The registry has also put a note of this effect before this court. In such circumstances, we are of the view that no further order is required to be passed in this. In these writ appeals, hence the same are treated to be disposed.
Note is already there, so it is being disposed of.
That is
Obliged.
Mr. D.K. Sharma, Lani, additional senior government.
For hearing, item 12 to 13.
This is appeal by the revenue against the order of the learned CCT. Substantial question of law was framed on 59/2021. Page 2, whether under the peculiar facts and circumstances of the case, CCT Calcutta was correct in holding the demand of Senbet credit of central excise duty utilized by the SEC was barred by limitation. The impugn order starts at page 34.
December 2000.
Let's see, 4th of December 2000 and. Question. 19 lakhs.
Sister was correct to the ground. This is a question of law.
Limitation lordship is a question of law. Because lordship may come to page 37.
It's a mixed question of law and fact.
Lots. Let's say page 37, the respondent here, lordship, they didn't.
Just. the dispute is regarding only interest.
Yes, Lordship. Lordship, demand
He's
of proof
already
is,
paid and as soon as you issue the show cause notice, he has already paid that.
Lordship, here, Lordship, when the audit was conducted, after the anomalies was pointed out to the respondent, they reverts about 8 crores and something. And the rest of
That was
them, rest of the amount they didn't credit. Their contention, they file appeal and in page 37, Lordship,
No, these fact. The CTET has observed as this. In para number 4,
Lordship, page 30.
the learned women, they argued that there was no intention to submit credit. As soon as it was pointed out that the credit is not available, they reversed the credit to the balance amounts remaining unpaid. In his submission, that the definition of has been amended only on whereas the trading activities are included so and so, so and so. He submitted that the SSC is not contesting his case on merit, but solely on limitation and
Yes.
the entire detail was duly submitted. And service tax is did not only they failed to consider, but also so and so. He relied on various decisions of the tribunal where it has been held so and so. Now your case was on the contrary, learned DR. Appearing for the revenue submitted that the appellant is illegally not entitled to credit and therefore the claimant by the payment to service tax liability is liable to be recovered. He also submitted that the appellant is also liable to pay interest by placing reliance on so and so.
Lordship.
We find that in the present case, since the credit amount is legally not eligible, the appellant is not contesting the demand of merit, but only on limitation. The appellant has submitted the credit availed wrongly without any intent to evade tax so and so. Course of adjudication is specifically submitted so and so. So if they have already deposited or returned the whatever the credit illegally availed, then
Not entire amount, Lordship.
entire amount,
Lordship,
there is no dispute about that.
They liable to pay, Lordship, my note, Lordship. Last 4 lines. Balance of rupees 1 crore 27 lakhs, 3,078 as service tax, rupees 2,54,000 as education cess, and so. This amount, getting 1 crore 30 lakhs, it is able to be paid by them, Lordship. They have reverts only 8 crore something, Lordship. Now their contention is that this demand is barred by limitation. But Lordship, when they held the Sembate credit wrongly under rule 3 and 6, they cannot be.
What was the total illegal benefit this
Lordship, about 9 crores, Lordship.
9 crores?
Lordship. They reverse 8 crores something, 8 crore 58 lakhs. Remaining amount is 1 crore 30 lakhs. And they have admitted,
This is of interest amount or
no, including Lordship tax. Lordship,
interest including the tax?
in this amount 1 crore 30 lakhs is including the tax and interest. And Lordship has seen the paragraph page 37. They have admitted, but they are contesting the case on ground of limitation only. And my contention is that they have held the Sembate credit wrongly in violation of rule 3 and 6. When they have held the wrongly, then extended period of limitation can be from the section 73 of the Finance Act 1994 laws. And Lordship, again, I'm placing that paragraph, Lordship has already page 36. He submitted that the SEC is not contesting the case on merit, but solely on the limitation as much as The entire details were duly submitted in the service tax. Lordship, another thing, why extended period of limitation was invoked? Because it is impossible to go to find out their anomalies after looking after return under S3. Only after the audit was conducted, all these things came. And as soon as it was informed that they reversed part of the amount, but remaining was unpaid. And now their contention is that the entire demand is barred by limitation.
Now, how it is barred by limitation?
They
Barred of
said
which
that
clause?
because it is beyond the period of limitation, normal period.
What is the period of limitation?
Lordship, I'm pleased. Section 73. Merit lordship. Recovery of service tax not levied or
73 of which act?
service tax lordship, Finance Act 1994. Let's say that might be. And this is the case of the respondent lordship, that this amount which was not reversed by them was barred by limitation. So my argument before a lordship, when they've admitted
73,
73,
what is that, which provision you are referring to regarding limitation?
73(1) is lordship, there is an exception to the normal period of limitation. There are 4 grounds are available before the authority when the extended period of limitation can be invoked.
What is the relevant date?
Is related to period from 1/4/2009 to 39/2011.
So the normal limitation is 30 months.
Second,
And in case of these 4 contingencies, the limitation is extended up to 5 years.
5 years. Also, may peruse page 19 of my memo package. The part of demand some common notice. There is an explanation. Page 19, last paragraph.
Yes.
Merit. There is also, whereas it also appears from the above that the notice has been taking ineligible sandwich credit with effect from October 2009, and after partially utilizing the sandwich credit, a reverse in amount of rupees 8 crore 82 lakh so and so on 31/3/2011, but interest thereon is yet not paid. Rule 14 of the sandwich credit, Rule 2004 stipulates that where the sandwich credit has been taken and utilized wrongly,
The same along with the interest shall be recovered under section 75 of the Finance Act 1994. Whereas the notice has reversed the principal amount on their own assessment, the interest thereon rupees 1 crore 19 lakhs stands recovered from them. Then table is there, next paragraph, page 20. Whereas it appears that the utilization of Senate credit rupees 1 crore 27 lakhs odd as service tax and rupees 2 lakh 4,080 as education says and rupees so and so as secondary higher education says aggregating rupees 1 crore 30 lakhs so and so only for payment of service tax is not permissible in terms of the provision of Senate credit rule 2004 and the same is liable to be recovered under rule 14 of the Senate credit rule read with proviso to section 73(1) of the Finance Act 1994 along with interest thereon under section 75 VD invoking extended period of 5 years for contravention of rule 14 of Senate credit rule with intent to evade payment of service tax and hence they are liable to penal action under rule 15 of the Senate credit rule read with section 78 of the Finance Act 1994. Therefore, in original lordship, this was affirmed.
In view of the above notice, hereby called upon to show cause Commissioner of Excise on 30 days by the ineligible Senate credit as service as secondary credit so and so, so and so, so and so wrongly being utilized by them
Yes, sir.
be recovered from them with interest prevailing so and so. So this was the amount 1 crore 27, 2 lakh 54, 127 and 130.
130 is aggregating amount is 130, 1.3 crore.
Okay.
Aggregating
Education
amount.
cess and secondary and higher secondary education cess.
Okay, this 1 crore 27 lakh, 254 and 130.
Lots of. And this was confirmed by the assistant commissioner of Central Excise. That was the
Man, कह रहा है कि 1 crore 30 लाख से रहेगा, Calculation sheet, work of the. Unutilized segment credit of 1,27,03,780. Service tax, as service tax, with a way principal, education sales. Secondary and education sales, सबको मिला के एग्रीगेट 1,30,00,000. 1,30,00,000 है ना? ये है ना? इसमें कोई नहीं है.
Actually, the further finding of the commissioner, let's say peruse it page 29. Will that will clarify everything.
Page 29.
Page 29, paragraph 4.5 and 4.6. Yes, married law. Paragraph 4.5. On perusal regarding the first aspect, that is whether the sandwich credit can be taken or utilized by the said notice, it is observed that the said noticee have never argued disagreed with this fact. Instead, they have submitted that the credit under dispute was taken with bona fide belief that the same are eligible for credit under sandwich credit rules. They had also reversed the credit taken but not utilized, which obviously proved that they have taken sandwich credit wrongly. Moreover, they have taken sandwich credit of central excise duty, including education cess, secondary and higher secondary cess on inputs, which was exclusively used for provision of exempted service, that is supply of materials, and use the same for payment of service tax on taxable service, that is erection, commission or installation service. Sandwich credit is not eligible as per provision of the Sandwich Credit Rule 2004. Therefore, it is constituted that they have taken the utilized sandwich credit wrongly, and also they cannot utilize such credit under Sandwich Credit Rule 2004. Then paragraph 4.6 regarding whether wrongly utilized sandwich credit is recoverable under the interest thereon in terms of provision of section 73 and 75 of the Finance Act 1994 by invoking extended period. I have perused the erstwhile rule 14 of the Sandwich Credit Rule 2004, wherein it is stipulated that where the sandwich credit has been taken or utilized wrongly or has been erroneously refunded, the same also with the interest shall be recovered from the manufacturer, the provider of the input service sales, and provision under section 11A and 11AB of the Central Excise Act or section 73 and 75 of Finance Act shall apply notice modernity for effecting such recovery. However, the word taken or utilized wrongly has been substituted by the words taken and utilized wrongly by the notification number so and so with effect from 17/3/2012. The said noticee claimed that they had submitted ST return along with relevant records and documents, and no facts was suppressed or misreported. Moreover, they have submitted that the credit under dispute was taken with bona fide belief that the same are eligible for credit under Sandwich Credit Rule, and credits so taken and utilized were duly reflected in the relevant returns, as well as submission of the said returns were duly made to the proper officer, enclosing all the relevant documents where the details of the credit were reflected, and the credits were in knowledge of the department, and no objection was raised by the department, nor the department has ever said that the credit was irregular until the audit raised objection by audit report number so and so, audited on 27/3/2012 and 22/28/2012. The object in question was raised on 28/3/2013, that is after 2 years, 11 months, 1 days. In this regard, I find that the mere submission of return may not be sufficient obligation for a service provider to avoid misstatement or suppression of fact. There may be some element of misstatement or suppression of fact which may happen even after regular submission of ST3 returns. Hence, the department is required to investigate or to audit an SSC under the umbrella of the department. Besides, I find that the said notice has taken and utilized ineligible Senate credit, violating the provision of Senate credit rules 2004. They have even did not reverse the wrongly taken credit until audit has pointed out. After the completion of the audit, they reversed the amount of Senate credit which was not utilized up to the date of audit. Had the audit not unearthed the fact, it would have been remained hidden. Therefore, I find that there was an element of misstatement and confirmation of service rule with intent to evade payment of service tax. Had the audit not pointed out that they would have utilized the whole amount instead of reversing the ineligible Senate credit, which was wrongly taken, and thereby they might have evaded payment of service tax or payment of taxable service. So the ineligible Senate credit that were utilized for payment of service tax for providing taxable service under the category of erection, commission, or installation is required to be recovered in terms of Rule 14 of Senate credit rule as read as with section 73(1) and 75 of the Finance Act 1994 invoking extended period. I therefore find that the allegation in this regard is sustainable and maintainable. The amount of Senate credit rupees 1 crore 30 lakhs and all only wrongly taken and utilized by them towards the payment of service tax, education tax, so and so. The C is required to be confirmed along with the interest thereon under section 73(2) and 75 of the Finance Act 94. There I find that no such time but factor case, this case we claimed by the notice.
Mr. Sahiwala, today this bench is not available in the second half.
My lord.
But what we would like to request you is if you can give it in a tabular form. Mr. Kyle has given something, but we wanted in a tabular form. What is the amount? Which are the components? What according to you was the relevant date? And why do you think it is barred by
My lord.
some projection?
You are well certain, whatever the Senate credit was not, you were not eligible for that. And your case is that you have already paid that, whatever the Senate credit return that which you have wrongly availed. How much amount you have availed and how much amount you have deposited, and is there any remaining amount or no remaining amount is there? Thoda sa, you please give us a chance.
Mainly, my lord, here, the extended period of limitation. Normally, it is 1 year. 5 years, my lord, there are several, my lord, judgments of Supreme Court also, my lord, where it can be invoked. My lord, that is not there. Suppose I have taken wrongly something, then only 1 year, my lord. Except the extended period cannot be, my lord.
No, until and unless these 5 contingencies are there,
my lord.
they can't extend it
Yes,
to that
my lord.
5 years.
These
That's why-
factors are to be there, my lord.
So what we are saying that your case is that you have already the Senate credit
Yes.
wrongly availed, you have already returned or deposited,
My lord.
refunded.
Yes.
How much amount you have availed and how much amount you have refunded? We
Well-
want some clarification on
My lord.
it.
With the dates.
With the date. Next. 25th June.
Lordship, these figures are available in the order in original at page 29, paragraph 4.2.
Actually, yeah, from this, we have not been able to, what you have submitted your this facts of the case, and we have not been able to gather this.
No, but the
It's very
table,
confusing.
not Lordship file. If you could, I'll give a place.
You also gave, and
Yes.
he will also give, we'll compare it.
Lordship, item 13 is different case, not related to this. This may be taken up on some other.
After summer,
After item 13, after summarization.
So summary is not really good. Maybe after 16, after the session.
After summarization.
my lord, my frame is showing the, my lord, standing council of, Plan and review.
To reflect the name of SC step revenue in the.
Which matter?
Item 16, your lordship.
Item number 16, this after so and so while showing name of
16 item,
16.
Yes.
16,
After showing name of so and so after summarization.
my lord.
Reflecting the name of so and so after summarization.
Orders, item 1 and 2.
Where is the review petitioner?
Review petitioner is the state government.
We have preferred the review petition, Madam. Lordship may kindly take up the review petition. In the review petition, basically, Madam, in paragraph 5, 6, and 7, at page 6, no, is our case, Madam.
It's now getting bifurcated. So is made mining by. So if that decision they want to implement that. They immediately wrote it. We will do so. Whatever. Possible.
Why this order? You seek review of this order.
But I have paid for review of the order at page 12 and page 17. But Lordship, may I kindly come to page 16, my lord. The order, the last paragraph of the order.
Yeah.
By which my Lordship has directed while disposing of the writ petitions with a direction to the state government to initiate the process of selection for promotion to the post of director in the Director of Geology and Mining in accordance with law.
In accordance with law, in accordance with law.
That is what, kindly, if Lordship kindly comes to ground B, my lord, we have narrated, my lord, to what is the difficulty we are facing. Lordship has also directed me to have the records. I have the records, my lord. From the records also, I will.
It's a question of record. You just, para B.
Yes, my lord.
Yeah.
For that, the Mines and Minerals Department wants to bifurcate the existing Geology and Mining Department by creating two separate independent directorates, namely Directorate of Geology and Mining for administrative convenience, wherein the technical scientific work shall proceed under the Directorate of Geology with all personnel under the Directorate of Geology and administrative responsibility, including revenue collection, shall be with the Director of Mining, who will be the administrative from the administrative background, whereas the existing service order provides that the post of Director of Geology and Mining Assam is to be filled up by promotion from the cadre of Joint Director Chief Geologist without amending the said service order. It is not possible for the government to take a decision as proposed. Further, the Honorable Court by order dated 23/2/2022 passed in WPC number 41, this order which we have sought for review, my lord, is also holding the field. Therefore, the order dated 23/2/2022 passed in repetition number so and so, and the order dated 17/8/22 passed in contempt case number 451 so and so may be reviewed suitably, considering the intention of the government to amend the service order for filling up the post of Director of Geology and Mining law.
How, where is the restraint order by this court that you can't amend the rules, you can't bifurcate the directorate in two parts? Where is that?
But the difficulty which the department.
If you yourself was creating a difficulty, there is no order in
No,
this.
no, there is a positive direction of the Honorable Court, my lord.
Simply, where is the positive direction?
My lord, at page 16, my lord.
Yeah.
Page 16, kindly see, my lord.
Today, we have been informed that now one candidate department, we therefore dispose of the, with a direction to the state, initiate process of selection, promotion to the post of so and so, in accordance with law, do it in accordance with law.
And my lord, kindly come to page 18.
18, yeah.
18. That was further, my lord, clarified.
Yeah.
The last para, we deem it fit to direct the authorities to implement the directions issued by the division bench of this court in its order dated 23/2/2020 within a period of 2 months from the date of receipt of the certified copy of this order. Means the process,
If
promotion
you
process
have
to be
not been
complete.
able to conduct these in 2 months, you now do it by amending the law. There is no question of any review of this order, sir.
No,
There is no restriction
But
imposed.
if the promotion is done and the director post is filled up,
Yeah.
but ultimately the policy decision which the government wants to now take, that if the person is holding for.
Take the
like-
policy decision in accordance with law. What do you mean by in accordance with law?
Look-
The day when you are going to complete the selection process, the law on that day is applicable.
Well, the government
Sir,
doesn't want.
sorry, yeah, this can't be a question of review, sir.
But the government
This
doesn't.
can't be a review.
Well, this is a subsequent development, well,
Subsequent development, therefore, what is the error apparent in this
No,
order?
there is no error apparent, but the order holding the field, well,
Sir, this is not the scope of the review that seems in Now you have contemplated to amend the rules, therefore the earlier order should be reviewed. There is no such order is there.
But the lordship has directed that the promotion process has to be completed. If we promote a person for, he will hold the post for 3-4 years.
Yeah.
Then in that case, my lord, the decision of the government to
We
bifurcate
don't find
to-
any case for review, sorry.
But kindly appreciate the.
Yes, we have already appreciated. Nothing else. Look here, this review petition is filed by, without any baseless reviews. Sir, not even a question of review of the order is there, sir.
But
How can you file such review petition, sir?
kindly, my lord, kindly consider, lord.
Sir,
The-
we have already considered your argument. We
But
have
the
taken into
order-
consideration, since you are now you're trying to implement a policy whereby to bifurcate the directorate in 2 directorates.
But
And for that purpose, you want to amend the rules. Therefore, the earlier order should be, then it's very difficult.
But-
This can't be the scope of review.
But-
Who advised you to file this review?
because of the subsequent.
What type of advice, if you have such type of officers, legal officers who are advising you to file you review in these matters, then it's
But
very sorry affair.
the honorable code or direction to complete the process to fill up the post by promotion is there.
Nothing.
But the government,
By this review petition, the petitioners have sought review of the order dated 23/2/2022, whereby while disposing of the writ petition number 4135/2018, this court has directed the state government to initiate the process of selection for promotion to the post of director in the Directorate of Geology and Mining, Assam, in accordance with law. Full stop. It is contended on behalf of the review petitioners that after passing of the order dated 23/2/2022, the state government wants to bifurcate the existing geology and mining department by creating 2 separate / independent directorates, namely Director of Geology and Mining for administrative convenience. Full stop. It is contended that the government is also intending to amend the said service order by making necessary amendment in the provisions of the act and the rules applicable. Full stop. It is contended that on account of the order dated 23/2022 and the order passed and the order dated 17/8/2022 passed in contempt case number 41/2022. The government is finding difficulty in bifurcating the existing geology and mining departments and the existing geology and mining directorate and in passing of the and in amending the corresponding provisions of the act and the rules. Full stop. Having heard the learned counsel for the review petitioner, we are of the view that this court has simply directed the respondents to initiate the process of selection of promotion to the post of Directorate of Directorate of Geology and Mining, Assam, in accordance with law. And this order cannot be said to be, and this order can't be treated as an impediment in the decision of the state government to bifurcate the existing geology and mining department by creating 2 separate directorates. Full stop. This order is also not creating any impediment in the decision of the state government to amending the corresponding Act and the rules will stop. In such circumstances, we don't find any case for giving the order dated 23/2022, the review petition is dismissed. Follow, please. Who advised you to file this review petition of this nature?
So we thought that it is an.
I'm sorry, sir.
One point out, my lord, if your lordship kindly permits, your lordship in the order dictated that their decision to bifurcate, they are yet to take a decision. Madam.
No, I have the,
Maybe they may take. or
I
may
have
not
the,
take.
I have the record.
This will be,
I have-
if that is question, we'll consider it, but certainly this order can't be reviewed in this. Sorry.
Hold on.
So far as the contempt petition tagged to this matter is concerned, my lord, this can
Contempt
come in a
petition,
regular bench.
number so and so to be listed before the concern. Roster.
How nice.
It's not.
Item number two. Item number two listed.
Item number 3.
My lord, as per the last order, we were directed to take steps through paper publication and file affidavit. Accordingly, we have done that.
Who is appearing? Respondent number? 26, but what about respondent number 1, 3, 4, 4, 5, 6, 7, 9, 10, 11, 13, 16, 17, 18, and 19?
My lord, I have already taken steps. They have, my lord, as per,
Anybody is appearing?
my lord, as per the case status I checked in the morning, there's no Wakaratnama has been filed till yet.
Paragraph 1. Paragraph 2. Here, paragraph 15. 5.
Should be on.
It has not been specified.
Mr. Counsel,
Hello.
see this notice published in the newspaper.
My lord,
So on which date you ask them to appear before this court?
my lord, as there was no date being mentioned in the order, that is why the registry did not mention it, just mentioned the date after 2 weeks. My lord, I,
Talk to me.
My lord,
Even though this court has not indicated any date, registry has to give the date. On which date otherwise the person would appear before this court. You are hereby informed to appear either personally or through your engaged counsel in this honorable court and to show cause if any. Which date?
my lord, that date has not been mentioned.
No, without date being, how to appear? Which date?
I absolutely understand, but my lord,
Yeah, that is the update. It's not-
Please notice that. Pursuant to the order passed by this court on 8/4/2024. The petitioners got published a notice in the daily newspaper.
Type C.
Daily newspapers. Ahomia Pratidin and the Assam Tribune respectively. However, from the perusal of the said notice published in the newspapers, it is clear that no date has been mentioned for appearance of the respondents number 1, 3, 4, 5, 6, 7, 9, 10, 11, 13, 16, 17, 18, and 19 has been indicated. It's stop. In view of this fact, we are unable to accept the effective service of notice upon the aforesaid respondents. Hence, the review petitioners are again directed to issue get the notices served upon the aforesaid respondents through paper publication in the daily news, in 2 daily newspapers having wide circulation in the state of Assam for the state of Assam for appearance of the aforesaid respondents before this court on 22nd of July 2024.
my lord,
Learned counsel for the review petitioners shall file an affidavit regarding the service of notice upon the above mentioned respondents through paper publication within a period of 2 weeks.
my lord, may I just pray, my lord, before my lord passes away the order? My lord, may I be allowed to take steps to the office, to the government office, my lord, because they,
We have already asked for this paper publication, we will again do it.
Item 4,
Well, item 4 and 5, as out of the same thing, my lord. My lord, it is there are intermediate which I have filed. And of late, my lord, after almost 1 year, the FCI is again filing a that day only review petition. My lord, these are all offshoot litigations. What has almost 1 year passed? What, my lord, I humbly suggest that everything may be brought to a end, my lord, so far as this case. And if your lordship permits me, then, my lord, it will not take much, my lord, 10 minutes about the facts of the case and then the learned single judge's judgment to see whether it entails any interference by these division bench. Then your lordship will take care of.
This is a review petition, and the review petition is filed after your own submission before the learned single judge. That we would like to avail the remedy available to you before the redressal grievances committee. We are not going to.
So the respondent.
Please for the respondent. This is
There-
your review, na?
Yes,
There, my lord, only
My lord.
one thing will arise there, my lord. It is a contract concluded, my lord, 5 years ago.
Yeah.
Everything was concluded, payment was made. After 5 years, they suddenly said that the distance was less than what you covered. Under such circumstances, whether the dispute redressal will come, there was no dispute at all. That is my case.
Why you have filed, you have also filed review petition.
No,
No, my lord.
No,
You have not filed
no,
any
my lord.
review. Then.
Read appeal was dismissed by your lordship's minor division bench on withdrawal by the learned counsel for the absent. The matter ought to have ended there.
But then.
Then they filed an interlocutory application asking for some more rider. Then that rider was given. That was not a review petition. Then with that rider, my lord, I found in an,
This
Solvency.
solvents, surety.
yeah, I filed that idea.
That's solvents.
They filed, I filed. So the entire, my lord, offsuit litigation should come to an end. That's what, my lord, I am humbly submitting.
Litigation
Now
has
lordship may
already-
take care of the review petition.
Has already come to an end. We are not going to review this.
My lord, if I able,
Your own submission.
if I am allowed to submit, my lord, why this review petition has been filed, my lord? First of all, my lord, the writ appeal was
Since
This
you are saying.
was
that
withdrawn
the
at- or-
Authority redressal grievances committee has no authority to look into your grievance filed by the FCI.
because
This is what
FCI
you-
cannot go to the GRC, my lord. It is the contractor who will go to the contractor, because otherwise the FCI will be the judge of its own cause, my lord. That has to be rectified, my lord.
Why should I go?
No, that is okay, but on our submission, my
No
lord,
dispute.
on our submission, we have made a submission that we will go to the GRC. That was a
No,
wrong
no.
submission, my lord. That in fact, my lord, it has to be rectified. Only that much is to be done, my lord.
No, it would have.
Only that much is to be done, my lord. Otherwise, FCI cannot be the judge of its own cause, my lord.
And this review is after 357 days of delay, my lord.
I have filed one
Lordship
IA
will see
application.
whether there are explanations for that.
We know file. Clause 20. One of the last. Double X. The dispute resolution. No, don't then dispute. This. Case of dispute. It was no. When the council were applying the statement that we go to the dispute resolution. They know by the review, saying that this was the wrong statement. And if they want, they can come to dispute. Only clarifying that you have to be contractor, meaning there has to be an agreement.
My lord, this review petition has been filed to correct which has been submitted on the last occasion, my lord. My lord, may I kindly come to page 177, my lord, in the review petition. May I read the operative part of the judgment, my lord? The learned senior counsel appearing for the FCI submitted that he would like to withdraw the appeals, taking liberty to this court to approach the appropriate forum, including the grievance redressal committee. Thereafter, the liberty was given to withdraw this writ appeal. When the FCI regional office approached the journal office for the GRC, my lord, that they have approached on 5/9/2023, my lord. Then it came to the knowledge of the GRC that FCI cannot approach, my lord. I would like to just point out two documents, my lord, at page 178 of the writ appeal, my lord, review petition, my lord.
Yeah.
Page 178. It's an annexure 3, my lord. May I read the appropriates to the direction of the Honorable Punjab and Haryana High Court in so and so, wherein the court has advised to develop the in-house mechanism to deal with the grievances of the tenderers in the contract matters. The matter has been deliberated upon in headquarters on the direction given by the Honorable High Court. The competent authority has decided to constitute a committee of GM contract, GM accounts, and DGM legal at zonal level to redress the grievances of the tenderers arising out of the awarding of the contract based on the recommendation of the above mentioned committee. ED zone shall pass a speaking order. So from 2000 onward, the GRC has been constituted in the FCI, my lord. Thereafter, in page annexure 4 at page 179, certain things were clarified that not the bidders of the NIT, but only the contractor can approach the GRC, my lord.
This is wrong interpretation.
No, I will read it, my lord. Please refer to the subject cited in this connection. Various issues relating to handling and transport contractor STs, HNTC and RTC have been examined by the committee interested at the headquarter level. Certain amendments in STC, RTC, MTF have been already been conveyed by this office letters of even dated 5/2/2020 and 6/2/2020. Further, the following clarification instructions are forwarded herewith for the compliance. That number 2, my lord, Roman 2, grievance redressal committee shall consider the matters only related to the contractors. That is the party to whom contract has been awarded. And
The matters related to the contractors, it doesn't say the matters of the contractors. Matters
department
only related to the contractor, the party to whom contract has been awarded, not, it doesn't, it has no way in specific that shall consider the matters of only contractors. Related to is a very
interpretation of the department is that it is the
your interpretation is certainly we can't
otherwise, my lord, if it can be taken in this way that
we
the
can't
FCI will
endorse
be
this
the judge of their
interpretation
own cause.
as per our view, we can't endorse this interpretation. Sorry.
Otherwise, my lord, the first document is clear that the grievances has to be.
Whatever it may be, now the clarification is there. It is of 2009 and thereafter in 2020, this clarification is there. Approach and you consciously approach this court, made a statement that we are going to approach the grievance redressal committee and it can't be the matter of review, sir.
That was my only submission, my lord, that because FCI cannot be the judge of its own cause and it is the only the contractor who can approach the GRC, my lord.
A review petition is filed. This review petition is filed by people I'm seeking review of the order dated 27/2/2023 passed by this court in writ appeal number 385 of the 2022, whereby the said writ appeal was disposed of taking into consideration the learned senior counsel appearing for the appellant, whereby the writ appeal filed by the appellants was dismissed as withdrawn while considering the submission made on behalf of the learned senior counsel for the appellant to approach the competent forum as per the provisions of law. The division bench has further observed that the finding of the learned single judge will not be a hurdle in approaching the relevant or the competent forum as deemed appropriate under the provisions of law. It is to be noticed that the division bench has taken into consideration the clause 20 of the terms and condition of the contract, which provides that in case of any dispute arising out of any touching upon the contract, the same will be first addressed to the dispute grievance redressal committee constituted and functioning at Zonal Office of the corporation with a view to settle the disputes. Full stop. It is contended on behalf of the appellants, on behalf of the review petitioners, that though the counsel appearing for the applicants in the appeal sought withdrawal of the writ petition, withdrawal of the writ appeal with liberty to approach the grievances redressal committee, but now the applicants came to know that the grievances redressal committee can consider only the grievances raised on behalf of the contractor and not on behalf of the FCI. This is the FCI. FCI. So stop. Learned counsel has invited our attention towards a clarification issued by the FCI dated 16/2/2020.
FCI headquarters,
FCI headquarters,
New Delhi.
New Delhi, whereby certain clarifications, instructions have been forwarded to the forwarded for compliance. Full stop. And it council has submitted that in para 1, clause 2, it is provided that grievance and redressal committee shall consider the matters only related to the contractors. And as such, the FCI cannot approach the grievance redressal committee as per the liberty granted by this court. Full stop. We have taken into consideration the above clarification, which we have taken into consideration the clarification number 1, clarification, which reads as under 179 pencil to pencil. We cannot endorse the view of the applicants that in view of the above referred provision or above referred clarification, the FCI cannot approach the grievance redressal committee and only the concerned contractor is eligible to invoke the jurisdiction of the grievance redressal committee. Full stop. The said clarification suggests that the grievance redressal committee shall consider the matters only related to the contractor to whom the contract has been awarded and not the bidders. However, it further clarifies that the role of the GRC shall cover the disputes arising during the period of the contract. In our understanding, the grievance redressal committee can consider the matters related to the contract arising during the concerned period. Stop. In such circumstances, we don't find any case for review. Hence, the review petition is dismissed. Pending IA is also dismissed.
My lord.
Yes.
My lord, I urge upon your lordships to dispose of the IA.
Yeah.
And my lord, the question basically is, I approached the learned single judge, not because of any dispute. Unilaterally, they imposed certain penalty without allowing me to confront, without a single sheet of notice, in complete violation of the natural justice. That was my case. My lord, I'll just give hindsight, my lord, it will take 5 minutes, see the nature of the, then I'll refer to 2-3 paragraphs of the learned single judge, then whether after withdrawal on dismissal, any rider was necessary, my lord, to implement the order. Lordship may kindly take the writ appeal, 385. Just allow me 5 minutes to refer to certain documents.
Yes.
Writ appeal 385. Lordship may straightway go to the, what is the matter that your lordships are handling, earlier handled by the learned single judge. Page 52. Page 52 was the NIT. Lordship may have a look. It was a NIT of April 2015 for a contract of 2 years.
Yeah.
Transportation. Now come to the box, my lord, serial number 1. Transportation of food grains, sugar and allied materials from ex-railway siding, JPR, JTTN. JTTN means, my lord, Jorhat town. FCI, FSD, Sinamora to Sipsagar complex, FSD, so-and-so, and ST Sipsagar via Webis. Distance is mentioned here, lordship, 78.185 kilometers. That this is the distance, you transporter come and give you a bit. Done, my lord. No, let's just,
Sir, we are, since we are not aiding the appeal on that.
no.
We are simply, how you are aggrieved by
No, my lord,
this,
in 2 minutes, I am coming to the,
how you are aggrieved by this condition.
yes, my lord, yes.
Of
So the
furnishing solvent surety by the order dated 7/8/2020.
Yes.
That's all.
25, so the date was mentioned. And in the appointment order also, the distance was mentioned. Appointment order also, my lord, the distance was mentioned. Lordship, kindly have a look at the appointment order and both, it was mentioned everywhere. So had it been said that the distance is actually not 78 kilometers, it is 6 kilometers less, I would have given a different bid, my lord. Am I clear to your lordship? Then contract was concluded. 2 years, 2017, the contract was concluded. All bills were paid after scrutiny. Then 3 years thereafter, suddenly, when for 2-3 years I didn't get back my security deposit, I inquired and I could discover this, my lord, at page 57. Unilateral imposition of recovery. Lordship, may kindly have a look at page 57. This is the impugned order against whom I came. Page 57. It makes reference to 2 letters which were never supplied to me. Observation raised by CAG, while letter number so-and-so reference, details are given that total amount recoverable is so-and-so, 80 lakhs, only as per the observation. Then, where from they will recover? The current contract is at serial number 1. Serial number 2 is from a different and independent contract, which I was running thereafter. Serial number 3 also different. No notice before this. This they have issued unilaterally. and without giving me any opportunity to confront. That was basically my case. And that too after conclusion of 5 years after conclusion of the contract.
Yes.
Now this being the position, so there was no dispute. To me, my lord, there was no dispute. I came for violation of Article 14 and natural justice. Even about all these alternative remedies, my lord, willful decision is very clear. When there is a clear-cut violation of natural justice, you don't go for. They cannot, after 3 years, 5 years, they cannot go to the civil court also. But by limitation now. Now, my lord, this judgment, my lord, after perusal of the my lord pleadings and hearing the parties, my lord, learned single judge, my lord, observe like this. I'll just read 2-3 paragraphs of the learned single judge, my lord. At page, judgment starts at page 134. Lordship may straightway go to paragraph 10, which is at 138. Paragraph 10. Okay.
Yes.
Just 2 paragraphs, my lord. Facts will be over. Paragraph 10 at page 138 of the learned single judge. I'm reading it, my lord. A reading of the aforesaid provisions of the NIT dated so and so 2015 makes it discernible that even if the contractor puts the rate in a manner otherwise than what the
Yes.
I'm reading the middle. If we take into consideration the said provision in the NIT dated April 2015, it would be apparent that whatever rate is accepted by the FCI would be for distance of 78.185 kilometers. That was specifically mentioned in the appointment order, also the NIT. And the said distance in terms of NIT cannot be reduced subsequently. And that too unilaterally by the respondent FCI. FCI now seeks to reduce the specified distance. The reason cited by respondent FCI may be good or bad, and without expressing any view, it is apparent that the quoted rate is for a specific distance which cannot be altered subsequent to entering in the contract unless a due procedure of law is followed at the time of entering into the contract itself. It is a settled law, my lord, Ramanna diagram. When they profess certain things before the public, they cannot make a somersault later on. You quote a rate 150 kilometer, invite us, all right, distance is 150 kilometer. Come and file your tender, quote your rate. Then after 5 years, you cannot say that actually the man, my lord, the general manager ought to have been responsible for it. He floated the tender at the highest authority. Then, my lord, at page 35, paragraph 35, 148, learned single judge. 35. This is how he concluded. Further, we have also taken note that even if the respondent FCI had arrived at a subsequent conclusion in favor of recovery because of any report or because of internal committee of the FCI had arrived at such
Mr. Bogura, just let us know what is the difficulty in furnishing solvent
My lord,
surety.
I come to that. But no material is produced
Sir,
before the
so
court.
that-
Yes, I am just coming.
That judgment has attained finality with the dismissal of their appeal.
Well, so
So there is no need to refer to that judgment. You
It's
just
all right.
tell us what is the problem
So
in
that
furnishing
is-
solvent
so
surety.
that is on that count. Now, my lord, coming to this, why it is not necessary, my lord.
Necessity is another thing. We are simply asking you, what's the difficulty in furnishing solvent surety?
My lord, it is
Necessary,
hazardous, it is hazardous 89 point so and so, around 90 lakhs, my lord. Per lakhs, we have to deposit, my lord, non-refundable amount of around 60, 70 lakhs, and that too for a duration of 1 year. My lord, the matter would have ended actually after withdrawal on this. That the matter would have. I didn't come for a review. They have filed an IA seeking an additional rider
And
that
in
let
that
him
IA
furnish.
In that IA, audience was given to you.
That was, my lord, the question
Audience
is,
was given to you.
No.
In your presence, this order was passed.
now, my lord, the predicament will be, predicament now, the division bench gave a rider, and that, on that too, in a dismissed case, in an interlocutory order. All right, interlocutory order. Therefore, I also came, instead of a review, by an interlocutory order, saying that one thing, it will be like presuming that I will be legally owing some money back to the FCI.
That can't be the present.
It will be giving a bank guarantee of 90 crores.
Sir, not bank guarantee, solvent surety.
No, my lord,
Bank guarantee is altogether different. Solvent surety is altogether different.
So-
You have to furnish a certificate from the revenue authorities, Tehsildar concerned that yes, you are having this much of assets in your possession. That's
My
the
lord,
only solvent surety.
That day, my lord, the FCI council actually requested that some undertaking should be given.
Sir, on that day, what happened? Forget
Anyway,
about
now-
it. Today, what is the
Yes.
problem in furnishing?
In the order sheet,
solvent
what
surety?
remains is what I am telling, my lord. Solvent surety, it will, my lord, it will defeat the, my lord, the direction for the, of the Sungiljas to pay the amount, my lord. I am prepared to give any undertaking if your lordship thinks, but in insisting on giving a solvent
Sir,
security,
there is no insistence. This is the order of the court.
so I want a little bit of modification of that order, so as to enable.
Sir, show us the difficulty that you are finding this difficult to furnish the solvent. Sir, he will certainly will consider.
Yes,
your-
that is what, my lord, that is what, my lord, solvent security, as I said,
What's the problem
no.
in furnishing that?
I have given a solvency certificate that I am a man capable, far more capable of giving you back more than 90 crores in the event of any lawful decree.
Where is that certificate?
No, yes, I have given.
Solvent surety of the-
What is that? Yes. Solvency certificate. My lord, I think I gave it to the, they don't, my lord. Yes. Sandy, I give. So this should be good enough, my lord. Solvency per lakh, my lord, imagine 11, 12,000 non-refundable and that too for not open end, for 11 months the bank gives. This should be, to the extent, my lord, lordship may modify. Once your lordship modified, gave them a rider, please don't deny, my lord, similar rider to me.
Sir,
That is my prayer.
What is the meaning of solvent surety?
So that will do, my lord.
Solvent surety, you will get the solvent surety certificate from whom?
From the bank,
No, not the bank.
bank, my lord.
Not the bank, sir. It is
Solvency,
by the concerned revenue authorities, Tehsildar or whatever the authority is authorized to do so, they will issue a solvent surety certificate.
my lord, solvency certificate, solvent surety is given by the bank.
No.
The amount is fixed. The amount is fixed. Every lakh, several thousands, my lord.
Right.
So that certificate should, and my lord, that will amount to, my lord, presuming that I owe them some money after all this, my lord.
This can't be the presumption, sir. Simply day in and day out,
If at all.
we are granting this indulgence. That
Now-
furnish the solvent security and get the amount. So there must be some surety in case the case decides against you. At least this is the public money. FCI is not a private entity.
Always,
It's a public entity.
always. Any other mode of my lord, security,
Okay, then bank guarantee.
bank guarantee will be equally, my lord, the entire amount will have to be
Then,
given.
then be satisfied with the solvent certificate.
Landed property, landed property, my own land,
You get a certificate from the concerned revenue officer,
lordship.
from the revenue officer who will give you a certificate.
No, really, my lord, the question is, your lordship has also ultimately said that pay as per the Learned Single Judge's directive. Now, if these are the hurdles before me,
Okay, sir, that, we
I am
don't-
in a great predicament.
Um,
And is it really necessary, my lord?
Still,
with
senior
respect-
counsel, now we don't find any this modification in the orders. We don't find any case for modification of the order, and if you are agree, you may challenge it
That's
before
all.
the appropriate forum. Sir.
My lord, that solvency certificate should be good enough, my lord.
Sir,
that-
no.
that I am a
that
man
is
of
for
cap-
the solvent surety, if the court has said, furnish the solvent surety and get your amount.
So in that case, lordship may give a lump sum amount of solvency security, my lord, which I can bear, my lord.
Solvent surety.
90
Okay,
crore.
1 crore solvent surety.
The amount is in 89
So
crore.
that's why only solvent surety of that amount only,
I cannot concede to that, my lord. Your lordship will have to pass it.
but that's all.
The prerogative is always your lordship.
This IA number so and so is filed on behalf of the.
Only your lordship may
Okay.
record my submission that it is cumbersome and my lord, it is burdensome.
Fine.
That may be recorded.
Fine.
Now, always it is your lordship's prerogative.
This IA application is filed on behalf of the applicant with the prayer to modify the order dated 7/8/2023 passed by this court in IA number civil number 1398 in writ appeal number 385/2022. Stop. The IA number, the writ appeal 385/2022 was preferred by the non-applicants challenging the order dated 3/11/2022 passed by the learned single judge in writ appeal, the writ petition number 2126/2022. Whereby the learned single judge has interfered with the recovery sought to be made by the FCI and allowed the writ petition filed by the applicant to stop. The writ appeal number 385/2023 22 came to be disposed of as withdrawn while granting liberty to the non-applicant FCI to approach.
Not disposed of, dismissed. It's a dismissal.
Okay, dismissed as withdrawn while granting liberty to the counsel for the to the non-applicant FCI to approach the grievance redressal committee for redressing their grievances. Full stop. It appears that after passing of the order dated 27/2/2023 in writ appeal number 385/2022, the applicant FCI has preferred an application referred IA number
1398.
13
I number 1398.
1398
2023.
2023 seeking alteration of the order dated 27/2/2023 to the extent that applicant would refund the amount of rupees 89,99,853 to the petitioner with the reasonable period of time subject to furnishing collateral public solvent surety to be deposited by the opposite party to the satisfaction of the FCA authorities until final determination of the dispute under clause 20, Roman 20 of the contract agreement. Stop. The said application was opposed by the counsel for the applicant, the counsel for the applicant who has filed the present application. However, the division bench of this court has disposed of the said interlocutory application wide order dated 7/8/2023, while observing that the ends of justice will be met if the application is disposed of by directing FCI to release the amount due to the petitioner as directed by the learned single judge by judgment dated 3/11/2022, passed in WPC number 2126/2022, read with the order dated 27/2/2023, passed in writ appeal number 385/2022, within a period of 30 days from the date of receipt of certified copy of this order. Full stop. The respondent shall will also furnish a solvent surety to the satisfaction of the FCI in respect of the amount payable to, in respect of the amount payable. It is further directed that the FCI will release the amount as indicated within the period of 30 days, subject to furnishing a solvent surety by the applicant from the date of receipt of certified copy of the order. Stop. Done it. By way of this interlocutory application, it is prayed on behalf of the applicant that the direction of furnishing solvent surety be modified and the petitioner and the applicant be allowed to furnish undertaking instead of solvent surety. Stop. Then it consent for the applicant has submitted that the condition of furnishing solvent surety is too harsh and
Bank, my lord, charges non-refundable.
onerous to the petitioner.
Onerous.
Onerous to the applicant, and therefore the same may be relaxed and the
Solvency
respondent FCI, non-applicant FCI be directed to release the due amount on furnishing and undertaking of the applicant own.
of a solvency certificate. That was my submission.
It is also submitted that the applicant has already furnished a solvency certificate issued by the Indian Bank, Allahabad, and Allahabad,
Covering
and in the
the amount in
alternative,
question.
the a non-applicant FCI be also directed may be directed to release the amount while taking into consideration the said solvency certificate. That's all. Having heard the learned counsel for the parties and after going through the material available on record,
My lord,
particularly taking into consideration the fact that the order dated 7/8/2023, which is sought to be reviewed by the applicant by this interlocutory application, was passed after hearing the learned counsel for the applicant. Will stop the applicant and the court has passed the said order dated 7/8/2023, taking into consideration the relevant factors involved in the case. Hence, no case for grant of interlocutory application.
My lord, if your lordship with lordship may record one of my submissions, my lord.
Sir, we have already recorded. Honorable, since everything comes within honorable.
As of that, from no appropriate forum, there is any money degree or anything I. Premature.
Obligement.
Item 6.
My lord, there is a typographical error, my lord, we have filed in for correction.
My lord, before my learned friends, my lord starts, may I appeal for some time to file an objection to this affidavit, my lord, the review application?
Objection to?
Objection against the, my lord, the review application.
So still you have not filed any objection.
Oh, no, my lord, in fact, the delay was condoned the other.
My lord, I think my learned friend should be a little bit rational, my lord.
No, I am.
I can't object to his filing an objection. Please come to page 19, my lord.
90.
For the sake of litigation, let us not do litigate, my lord. Page 19.
My lord, this review was filed a law, 1 year.
You will grant you the time, let it, here is submissions.
My lord, what had happened? They filed a writ appeal. Then please come to subpara. Feeling aggrieved and dissatisfied with the judgment and order dated 39/22 passed by the learned single judge in 1441 of 2001, the original petitioner has preferred this intra-court appeal. Considering the directions issued by the learned single judge, more particularly in para 47 to 50 of the impugned judgment, we are informed at the bar that the said order has already been implemented in the sense that remand proceeding has culminated into an order of final settlement in favor of respondent number 7, which was the subject matter of challenge by the very petitioner before the learned single judge. But it should have been 7584 of 22. It could not have been 1441. That's the only thing, my lord. While dictating this, error has crept in. My lord, what has happened? Pursuant to the judgment in 1441, a settlement order was issued on 17/10/22. Yes. Now, my lord, we say that this 14, instead of this 1441, it should be 7584 of 22.
Sir, is it what Mr. Chaudhary has read from this order? Is it the fact that after decision of the 1441/2022, new settlement was finalized?
Yes.
And that was under challenge in the writ petition number 7, not in
7582.
Right, that is true, my lord. But the problem here is that, my lord, we had filed this appeal against that order in 1441. And my lord, there are certain findings by which, my lord, we are aggrieved. And the certain findings in the judgment in 1441 against which we were my lord, aggrieved. In the meantime, my lord, the matter has been remanded, and on the basis of the remand, my lord, the settlement order was passed. That can, in that, my lord, the writ petition that we have challenged the subsequent settlement order, we could not have taken, my lord, all these grounds that we have taken here, we have taken in this, my lord, appeal in against the order in 1441. And if, my lord, that those findings stay.
Sir, this review petition is filed by whom?
By us. So
they simply say instead of this reference of writ petition number 1441/2021, the number of the real writ petition or the writ petition challenging the fresh settlement be inserted. How you are being aggrieved by that?
7584 of 22.
My lord, if this is, my lord, not 1441.
Even though if this come to the notice of this court can suo moto correct this situation.
No, my lord, if your lordship says that, my lord, whatever finding is there, my lord, in 1441, that can be, my lord, agitated again, then, my lord, I have no objection.
No, sir, there is no question of why. How can it be agitated? This was the appeal. This is the appeal against the order dated 1441/2021.
Yes, I filed that appeal, my lord.
So, sir, that appeal has already been decided, sir.
My lord.
How can you agitate those in the concluded matter?
No, my lord, in the subsequent order of settlement, my lord, the grounds that were taken in the 1441, my lord, we cannot take.
What is the problem with that?
Even I am surprised, my lord.
No, you should not be surprised, my lord.
I am surprised.
I'm
I'm
surprised
really
by your
not
argument.
surprised because you both are together practicing since last so many years, so this might not be the first instance. But at least I am surprised.
My lord, the difficulty is that, my lord, subsequent, if my lord, this order remains,
It's 1441 was closed. Then the liberty was granted to raise everything you have, even 758. The ones are further surely that whatever grounds I had in 1441 or in the appeal. 1441.
So this, you mean to say that you want to raise all these points you have taken in this writ of appeal against the order passed by the single judge in 1441
my lord.
in that pending.
Yes, my lord.
That,
Otherwise,
that the division bench has already granted. you
Yes,
liberty.
last paragraph.
if that is clarified, my lord, I have.
So
no-
that is, it is the question of clarification.
No, my lord, because the only one of the subsequent repetition will be heard and subsequent repetition was not in the before the revision bench.
Sir, we are not even considering that, sir.
My lord. My lord, if my lord, this is for clarification, my lord, this is a review. They say it's my lord, typographical error. If it is a typographical error, my lord, it cannot be reviewed. It can be an application for correction. Anyway, my lord.
Okay, we will not treat this review
My lord,
application, we will
anyway.
treat it as a clarification.
My lord,
application. That's
if
all.
your lordship clarifies that, my lord, the grounds that were taken in the writ appeal, my lord, against that order, we
Sir,
can.
sir, we can't clarify anything else since the division bench has already ordered here this.
My lord, division bench has ordered that, my understanding, my lord, is that, my lord, 1441 should be heard again, my lord.
Not at all, sir.
Or this is
In
like
the
a-
light of the aforesaid considering peculiar, we deem it of the dispose of this appeal with the clarification that it will be open for the parties including to raise all the contention law points developed from before the learned saying here. Any observation made shall not bind the parties and the learned shall decide that it independently after consent. इससे तो क्या लिखेंगे? What else clarification you need?
my lord, the
Well, that's all. Please, now please. You are disagreeing to it. Please, Mr. Chaudhary,
Yeah,
please,
he
if you
is
allow
assisting
me.
me.
Yeah, you are assisting. No, you are very much, nodding like this, anything. So what's the problem in that? You just show if anything in your mind.
Lordship, when the matter was disposed of, my lord, on that occasion, 7584 is not before the honorable division.
Not at all, no.
Lordship.
Yeah.
That's why,
So the what subject matter of the challenge of the very petitioner before the learned single judge in writ petition 75. So it was not a fact that you have already filed a writ petition number 7584 or whatever
my
the
lord.
number may be, that was there, that was filed prior to passing of this order.
before, Lordship. Before.
So this fact, sir, how can it be, how you can challenge that order, even oppose this request, sir? I don't understand. Sir. Look here. This review petition is filed by the filed on behalf of the petitioners seeking review of the order dated 14/12/2022. Passed in writ appeal number 335/2022. Stop.
We're there.
In writ appeal number 335/2022. The appellants therein have challenged the validity of the order dated 30th of September 2022, passed in writ petition number 1441/2021. Full stop. In the writ appeal number 144/2021, the learned single judge has set aside the settlement of fishery in favor of the appellant therein in favor of the respondent who filed the appeal number 335/2022 and issued a direction to conduct fresh proceedings for settlement of the fishery in question. Full stop. Pursuant to the direction given by the learned single judge in writ petition number 1441/2021, fresh settlement was made in favor of the respondent number 7 of appeal number 3, appeal number 335/2022. Taking note of the said fact, the division bench of this court on 14/12/2022 has disposed of the writ appeal number 14/12/2020, writ appeal number 335/2022, while observing that the further settlement of the fishery in question is subject matter of challenge by the appellant before the learned single judge. No indulgence can be granted to the appellants. It appears that while referring to the subsequent writ petition, due to inadvertence, the number of writ petition number 1441/2021 is referred instead of the number of the writ petition which was filed challenging the further settlement of the fishery in question. It is submitted by the learned counsel for the appellant, for the applicant, that the correct number of the writ petition challenging the further settlement is, what is the number?
7584 of 2020,
7584 of
2022.
2022. It is clear that in the order dated 14/12/2022, instead of writ petition number 1441/2021, the writ petition number 7584/2022 should be reflected. Full stop. Learned counsel for the respondents have opposed the review application. However, not in position to dispute that the subsequent writ petition challenging the settlement of the fishery in question is numbered as 7584/2022. Stop. However, the learned counsel has submitted that, the learned counsel for the non-applicant has submitted that the review petition is not maintainable for several other reasons. Be that as it may, we are of the view that the reflection of writ petition number 1441/2022 in para number 3 of the order dated 14/12/2022 is either a typographical mistake or and or a decision of the overlook or a result of the overlook of the facts and circumstances of the case. Hence, we deem it appropriate to rectify the same, and it is ordered that in place of writ petition number 1, ordered that in para number 3 of the order dated 14/12/2022, in place of writ petition number 1441/2022. 21. Writ petition number 7584/2022 be read. With these observations, this review application is disposed of.
Develop.
इसमें देर में एक रिट डिसाइड हो जाती है।
Item 7 to 9.
My lord, can I take little liberty in respect of this case, my lord, some other demand? Today, my lord, I was not there. I reached very late night yesterday, so I couldn't go through it.
But in the morning, there was a mention that you were out of.
Yes, I was out, my lord. I reached very late.
Matter is very small. Very, very small. It's a matter of 5 minutes. Subject to my learned friend starts.
But he has already made a mention.
That's all right, my lord. It's a personal difficulty.
When
Any date convenient, because this is not a regular bench also. Next time, next day we'll do it.
next month, next bench is
Fine.
Should not be on 12th, my lord. 12th I'll be out of state.
may not be shared. 12th को नहीं.
Badi no.
Till so far, we have not decided to have a bench with Justice Sekia on 12th.